You guys are so close now. I'm like, it's freaking me out, you know? It's been like 3 years and you were like over there and now you're in front of me. It's crazy. So anyhow, good afternoon. Welcome to the Appellate Division First Department. I'm going to call the calendar in a few seconds. You know the spiel by now. This says that there are over 6 hours of argument requested. So that's not going to happen. Please keep in mind, we've read your briefs. We are aware of your arguments. It is imperative that you only ask for the time that you actually need in order to outline those arguments that you think should be outlined. First case, People v. Nelson Alvarez.
Good afternoon, Your Honor. For the people, 5 minutes, please.
525. Matter of Noah S. is submitted. Ostacher versus Clark.
Appellant. Afternoon, Judge. 8 and 2, please.
Respondent, 8 minutes, Your Honor.
6 and 2 and 6. Crestview SPV versus Crestview Financial.
Respondent.
So that means there's no appellant.
That's it, Your Honor.
Would you like to submit?
Submit.
Excellent. Thank you so much. That matter is submitted. Romero versus Valdez.
Appellant, Your Honor. 9 and 2, please.
626. People v. Kalia Schumann. That matter is submitted. Jiang versus Ping An Insurance. Yes, 525. So there's no, well, you're the respondent. Are you the respondent? Yeah, okay. Maldonado versus Rupert Housing Company.
Request 5 and 2, Your Honor. Just 5 for the respondent.
5-2 and just 5 for the respondent. Sonishen versus 1986 FNS. I do not believe there's an appellant. Did you wish to submit?
Request 1 minute.
You will have 1 minute. People versus Robert Hammond.
Respondent request 4, Your Honor.
Yes, 4, 1, and 4. Pentagon Federal Credit versus Popovic.
4 for the respondent.
424. Sklar versus 650 Park Avenue.
Appellant, Your Honor. 9 and 2, please.
5 minutes for respondent.
4, you didn't, I'm sorry, appellant, you were not requesting any rebuttal?
Yeah, 2 minutes, please.
424. Wallach versus United Synagogue.
For the appellant, Your Honor. 8 and 2.
For the respondent, 7.
8, 2, and 7. People versus Pedro Carnegari.
Appellant requests 5 and 1, Your Honor.
Respondent requests 5 minutes, Your Honor.
414. Martar versus Isa.
Appellant request 5 and 2, Your Honor.
424. First case for argument, People versus Nelson Alvarez.
Good afternoon, Your Honors. Ronald Zapata for Appellant Nelson Alvarez. And you're right, this is very close now.
It's very close. You need to step back.
This court improperly denied the request to instruct the jury on the defense and expanded definition of intent for robbery. The jury should have been instructed that appellant must be found not guilty if the prosecution failed to prove that appellant displayed the box cutter to retain the ice cream rather than to escape. Without the requested instruction, the jury instruction was confusing and did not properly inform the jury about being able to apply the defense. Now, if we look at how the court decided this, it made this almost a discretionary decision with no analysis whatsoever. The court stated that, like, yes, it it understood that the requested charge was a correct statement of the law and that it was vital to the defense, yet the court said that it was just inappropriate to provide the instruction, which is just...
So I watched the video, and I also obviously read the transcripts of the trial. What evidence was there in the record which would support such a charge?
The evidence that would support the charge would be that he did not have any of the ice cream when he left. And so under Gordon and other cases, that's enough evidence to give the jury a question of fact about whether he intended to use the box cutter
You're
to
saying that he
retain
didn't
the
have
ice cream.
any ice cream when he left. What do you mean? Because I think that's sort of belied by the video. Are you saying that he wasn't successful in leaving with the ice cream? Or are you saying that at the time that he employed the use of a deadly weapon, that he didn't have the ice cream in his possession?
He said once he actually left the actual vestibule of the CVS. So he had it.
The people's evidence is that by the time he left, he had already threatened the use of a weapon and he was still in possession of the ice cream. At least that's the people's case.
Yes, but because he didn't, he still had the supposed weapon on him. If the intent was to retain it, he could have very easily said, "No, I'm getting it. I'm coming back for it." But because the ice cream was left in the vestibule, like
But was it left, or was it that the bag ripped and it fell out?
well, it ripped and it fell out. But like if his
That's not an
intent,
intentional act where he just abandoned the ice cream, correct?
I'm sorry.
That's not an intentional act where the defendant just abandoned the ice cream.
But by him not coming back for it, he just left afterwards. Like if his intent was to use the box cutter to retain the ice cream, he would have came back for it. He didn't. And so I think the important thing here is that under Gordon, this is a question of fact for the jury.
Also, what you're saying doesn't make sense. He allegedly stole the ice cream, so you're saying that he should have come back for the
Well, he was still there. He was still in the vestibule when the ice cream went like off his bag, and so from that, the jury can infer that the reason that he showed the box cutter was the intent to escape. And not
I thought from the video and well from the testimony that he displayed the box cutter prior to his no longer being in possession of the ice cream.
he still had it at the time. He didn't have it after he was in the vestibule. So apparently the bag ripped while he was in the vestibule.
But prior to that, he had displayed the box cutter.
Yes.
So he displays the box cutter. He still has the ice cream. Now he's leaving. He's attempting to leave the store, and he loses possession of the ice cream.
Yes.
Right? Because it gets caught or whatever
Yes.
in the door. So your argument is what?
Well, this
If
is
he really wanted the ice cream, he would have picked up the torn
because
bag.
it was still right there. So that presents the question of fact for the jury, and the jury should have been able to decide whether his intent was to escape rather than to retain the ice cream. Because if it was to retain the ice cream, he obviously could have just like grabbed it and gone. But because the bag ripped and he just kept going, a jury couldn't.
What does the language "or immediate flight therefrom" mean in your scenario?
Okay, are you talking about in terms of the dangerous instrument
Right.
element? So, just to, this is kind of off topic there, but immediate flight would be like after the commission of the crime, and so I guess that's one of the reasons why this jury charge
Doesn't
was
make any.
given.
Why your argument doesn't make any sense?
Well, no,
One of the
it's-
reasons. The immediate flight therefrom is the immediate flight from the taking, from the crime, from the robbery,
Yes.
from the taking of the ice cream. So we're still. I mean, what you're doing. It seems that you're parsing it out. You're like stopping. You're stating that the robbery ended at the point where he no longer had possession of the ice cream because the ice cream got caught in the door. And you're saying at that point, the robbery was finished. There was no longer a robbery. There's no flight therefrom, according to your argument. And now we have something totally different. Now he's just attempting to leave the location.
Well, no. My argument is that you can infer what his intent was based on both events that happened before and after robbery. And so his intent can be inferred if he didn't just pick up the ice cream, that his intent was to escape the whole time and not to retain the ice
So
cream.
then the language in the statute or the immediate flight therefrom would have absolutely no reason. There wouldn't be a reason for it. It would have no effect.
Well, this is the issue with the charge I was given and the CJI charge, is that the immediate flight therefrom is with the dangerous instrument element of the charge. And when you read that element of the charge I was given to the jury, they don't give any kind of intent element for that part of the charge at all. And therefore, the jury from that can infer that there's no intent element for the display of the box cutter, which is not the law under Gordon. Under
Thank
Gordon,
you. You have time on rebuttal.
okay.
May it please the court, Matthew Colangelo for the people. The
Counsel,
reason,
does the pattern jury instruction prohibit the jury or prevent the jury from inferring what defense counsel wanted them to infer with regards to this to the escaping as opposed to flight therefrom?
not at all, Your Honor, and that's for two reasons. First is that if you focus only on the language of the defendant used or threatened the immediate use of a dangerous instrument in the course of committing a crime or the immediate flight therefrom, I think that language captures effectively the notion that a defendant cannot meet the elements of that offense if he uses a dangerous instrument for some other purpose like to escape. But there's a second reason, which is that the trial court's charge, which is also included in the pattern instruction, is separately charged the jury that the jury had to find that the people established beyond a reasonable doubt that the defendant forcibly stole property. Well, if the defendant forcibly escaped, then by definition he didn't forcibly steal property. So the charge not only effectively allowed the jury to conclude that if the facts had shown the defendant was simply displaying a box cutter to escape, then the elements of the crime couldn't be met, it allowed the jury to conclude that for both of those reasons, both because it charged them on forcibly stole property and because it charged the jury on course of the commission of the crime or the immediate flight therefrom.
Is there, as far as you know, because I couldn't find any cases that say this, is there any requirement that the defendant has to be successful in the taking, meaning he has to leave the store with the 21 pints of ice cream in order for him to be found guilty of robbery in the first degree?
Your Honor, I think Gordon holds the opposite. The court in Gordon confirmed that the people are not required to establish that the defendant continued to possess property after the commission of the crime in order for the jury to conclude beyond a reasonable doubt that first-degree robbery occurred. The court said that whether the defendant did possess the property could be a factor the jury could consider. Here, defense counsel argued effectively to the jury in summation that they should take into account that the property was left in the vestibule of the store because it snagged on the door on the defendant's way out. But no, there's no requirement at all that the people establish that he continued to possess the crime, and Gordon, in fact, holds the opposite. In any event, if there was error, which there wasn't, it was harmless error here given the overwhelming evidence. There was no basis on which the jury could have concluded that the defendant here used force for any reason other than to steal property. And those questions only arise if the court concludes that this argument is not waived. The people will rest on our papers for the argument on waiver. If there are no further questions, we submit. Thank you.
Thank you.
I think one thing that's very important to note about the dangerous instrument element, there's no intent element there at all. There's no way that the jury could have implied that the intent to escape would have meant a not guilty verdict here. There's no intent element there. And then the only time that the jury is ever instructed about anything about flight or escape or anything is based on that element. And because there's no intent element there, they could have inferred that there's that the defense that was presented was not a viable defense. And in terms of Gordon's about a sufficiency question. And so what Gordon was about is saying that it's a jury question once you have a question about the retention of property or not, whether the intention was to escape or to retain the ice cream. So it wasn't saying that like, oh, you have to find it one way or the other. That jury question, they said that question should go to the jury, which is exactly what should have happened here if the correct jury instruction was provided. Unless there are any other questions on that, I'll just quickly talk about the other 2 points in terms of the do not speculate charge that was provided after the jury questioned why the missing videos weren't provided. I say that the People v. Williams 5 NY3D 732 is controlling
So was
here.
there discussion about that when the note was presented to the court and to the attorneys? Was there
Yes.
discussion as to how to proceed?
Yes, and defense counsel requested that they only tell the jury that there is no evidence there, and instead the judge said, no, I'm going to give a speculation charge. And under
And
Williams,
so the charge stated that the jury was not to speculate as to why there were no other camera angles, right?
yes.
And so how was that prejudicial?
So under Williams, like when you tell a jury not to speculate on evidence, then the inference there is that they're not allowed to make any inferences based on the missing evidence, which is an incorrect statement of the law. And so what Williams says is not only do you give the speculation charge, but you also give them an opportunity to say you can infer things from the missing evidence, which, for instance, here, the evidence presented at trial showed that one video camera would have showed the front of the appellant going to the exit and would have shown whether or not he held the box cutter or not. And so for them not to present that evidence and for the CVS employee to say that that evidence was there, the jury could have inferred that people were lying about this and they didn't meet their burden here.
Thank you. Thank you both.
Can I just do one point on the excessive sentence? Just
No, you can't, but read your briefs on that.
Okay.
Definitely. Next matter is Ostatcher versus Clark.
May I?
Please, Mr. Ostatcher.
May it please the court. My name is Adam Ostatcher, and I'm the appellant in this appeal arising from the lower court's denial of my FOIA-related Article 78 petition. This case was here back in September of 2021, back when the district attorney's office refused to respond or provide any records in perpetuity to these and other FOIA requests. That, of course, violated FOIL. This court remanded the matter back to the administrative level, and then the respondents, again, refused to conduct any search for records, then misstated the records in order to claim they didn't possess them. And then, even though they said they didn't possess the records, they asserted exemptions for the records that they claimed that they did not possess. I'm going to let my brief speak to the fact that the lower court, A, applied the wrong standard of review pursuant to Bankin, which requires reversal, and B, failed to hold the respondents to the burden of proof pursuant to Markowitz. And I'm going to go right to the claim by the respondents that they could not locate, or that the responding to these three FOIA requests, which seek discrete.
Well, it was that they do not maintain the records in the way in which you're requesting. You requested a list of all those assistants who had been reprimanded or fired or whatever for misconduct, right?
No, and that's the critical distinction.
So what was your request for? Because there were like 93 of them, right?
There were 93, there are three here. What I requested was not a list, right? And it was purposely not a list, because if it's a list, then they can assert the Stengel versus Vance. And you were on the Stengel versus Vance, where the FOIA requester sort of list. The DA's office says we don't have a list. So when
So what was your request?
I requested any record they have with regards to any ADA employed by District Attorney Clark who committed misconduct, any record of any action taken by the DA's office.
What was the time frame, counsel?
It was anyone who was employed. At that point, I put this request in May of 2020. DA Clark came into office, I think, was it January of 2016? So it's a 4-year time frame.
But I thought you also requested anything prior to her being the district attorney as well.
So anyone who was employed by her who had prior misconduct. So it was
how
any
far
employee
back?
employed by her during this 4-year period of time, any records. And I didn't request a list.
Counsel, how far back does that go?
Well, it depends on the specific employee.
So you could have a veteran ADA who's there for 20 years?
Yes,
Whom this would apply?
yes,
And you asked that any record reflecting misconduct be provided to you, and you indicated that misconduct should be given its broadest possible, what did you call it? Meaning.
absolutely correct.
So where does that begin and where does that end? There's no specificity, is there?
As to what misconduct constitutes? Is that the question? Is that specificity?
Specificity as to individuals, as to dates, as well as to content.
Well, as far as individuals and dates, it's the employees who are working for District Attorney Clark during her then 4 years and a few months in office. As far as specificity, it's misconduct. Misconduct is defined in the Rules of Professional Responsibility. I think it's Rule 8.7.
Counsel, how should we view your requests in light of this court's decision in the matter of Jewish press? In terms of creating documents that might not be stored in the way that you're seeking them?
I'm not asking for them to create documents. I didn't ask for a list. They changed my request in order to say it was a list to assert that defense.
What you are requesting requires the district attorney's office to basically go back and look at every single employee every single ADA that's in the employee under the tenure of Clark, right? And then make a determination as to whether there's misconduct. And what I think that they're saying is that they don't have that determination pre-made. So in other words, they would have to go back and look at every single one of these files, maybe for 20, 30 years, to determine whether there's misconduct as you've defined it, which is very broad, right? You said misconduct should be given its broadest possible meaning, including but not limited to Brady violations, Batson violations, violations of any aspects of any ethical code. It's extraordinarily broad.
That was not raised at the appellate level, at the Article 78 level, or at the lower level. So while that argument could have credence to it, they didn't raise it. So it's been abandoned.
Okay, but what argument was raised was that they do not maintain the records in the format which would allow them to reply to your request. And what they would have to do is they would have to create a whole new listing and create a whole new way of making the determination. As my colleague said, they'd have to go through every single assistant district attorney in that office to determine whether or not he or she had ever been terminated, I guess, for misconduct. And then they'd have to figure out what constituted misconduct, right?
I refer to the rules of professional conduct for what constitutes misconduct. We all know what Brady is. We all know what Batson is. So there is no interpretation here. They didn't raise that.
I don't know. Could there be other instances or other definitions of misconduct by an assistant district attorney other than if they fail to comply with Brady or in terms of Batson, et cetera?
This is the same kind of request that's being made all over the state. It was upheld in the Civil Liberty Union versus the city of Syracuse in the decision that you issued back in March, the Civil Liberties Union versus Department of Corrections. People are asking for records of misconduct, disciplinary records.
Right, but I think the distinguishing factor is that in those particular circumstances, those records might already exist. As my colleagues have pointed out, this would require a now revisiting of a case file, a personnel file, for each individual employed as an ADA going back tenured before DA Clark, rather.
So going back to Aaron Law, which you issued, the versus Department of Education, right? In that case, and this is the Coughlin decision from the Court of Appeals, right? If you were going to say that a demand is, actually, I'm sorry, it's Konigsberg versus Coughlin. If a agency is saying a demand is overly broad or requires a Herculean amount of effort, they have to submit proof. Now, that's the Court of Appeals word, proof. There is no proof in this case. They didn't submit an affidavit. They didn't submit a certification on this point. What they submitted was unsworn, unaffirmed correspondence.
But we don't even have to, I don't even know that we have to address that point because the central issue, as mentioned by my colleague, that we decided in matter of Jewish press was where you have an agency, or in this instance, the district attorney's office, which does not maintain any centralized listing of ADAs, of assistant district attorneys, who have been terminated for misconduct.
It's not termination. And if you look at Flaum, the third department case,
Yes.
right? Flaum, that's a DA, they wanted misconduct. The court held that the DA did not meet their burden in showing it was overly burdensome because they did not address a digital or keyword search. The DA's office has to keep all these records going back 30 years digitally. They are mandated by law to do that. All they have to do is conduct a search. Misconduct, termination. Now, in the Aaron Law case, there was an affidavit saying there are 100,000 files. Within those 100,000 files, there are 300,000 documents. It would take us 900 hours to do this. There is nothing. There is no affidavit. They don't tell you how many people.
We'll hear from the district attorney's office.
Good afternoon, Your Honors. May it please the court, David Cohn for responding.
Counsel, if you could just address the issue of the unsworn responses as a basis for the support for your position.
Yes, Your Honor. In fact, that is specifically addressed by the Ratley case from the Court of Appeals that I submitted as supplemental authority. And Ratley says, Ratley v. New York City Police Department, 96 New York 2nd, 873, it quotes Section 89, Subdivision 3 of the Public Officers Law, which says that an agency is required under the Public Officers Law, quote, to certify that it does not have possession of requested record or that a record cannot be found after a diligent search. That's the statute. The Court of Appeals goes on to say the statute does not specify the manner in which an agency must certify that documents cannot be located. And the Court of Appeals went on to say beyond that, neither a detailed description of the search nor a personal statement from the person who actually conducted the search is required. Here, there was a certification in the RAO's determination letter that a diligent search was conducted and that it was impossible under the circumstances to locate the records that are responsive to his request. And the reason is, for all the reasons that were discussed during petitioners'
So
argument.
your adversary states that you're required to maintain these records digitally for 30 years or what have you. So why is it that you cannot just plug in misconduct or Brady violation or something of that nature, and it would pull up the names of the assistant district attorneys who fall under that category?
Well, Your Honor, that whatever regulations he's pointing to is certainly not borne out by the realities and the record in this case. And what we have in this case is the record, right? And we have the RAO's determination, and the RAO is an officer of the court, he's an attorney, he's an officer of the agency, and an officer of the court. And he said in the determination letter, there is no listing of attorneys that have committed misconduct.
So does it make a difference that he's not asking you for a list?
Yes.
Rather, he's asking you for the underlying document?
Right. Your Honor, absolutely. He's not asking for a list. The reason that's important is because it goes to the reasonableness of locating the responsive records, right? Because if there's not an index or a list, whatever you want to call it, in a lot of the cases that petitioner cites are situations where there were actually indices in the agency's possession, and they could go down a list, like maybe the NYPD has an index of misconduct complaints, so they can say, all right, these were the officers that were adjudicated for this particular violation and that particular violation. They can search those officers' records. The RAO's determination letter here says there is no such index, whether you want to call it a list or an index. There's no such index in the district attorney's possession. And in order to create an index, and whether my opponent likes it or not, it's necessary to create this index in some form in order to respond to his request.
So, counsel, I'm looking at Public Officers Law Section 8938, which says that there's basically nothing in the law that requires any entity to prepare any record not in its possession nor maintained by such entity. My question to you is the nature of the request where your adversary defines misconduct as language that should be given its broadest possible meaning. In your view, is misconduct a subjective or an objective standard? Is it one that can be applied readily?
Well, Your Honor, I believe a FOIL requester, a FOIL petitioner has to have some specificity to the request and has to explain what they mean by misconduct. And actually, petitioner here is an attorney, and he understands how to define terms, and he defined the terms extremely broadly, as was noted. And in his definition, misconduct included not only terminations, but any Brady violation, so that could be any time a piece of evidence, a piece of Giglio material was not
And
disclosed.
also, any conduct that, while not resulting in public sanction, resulted in internal sanction or reprimand, for example, failure to properly prosecute a matter resulting in the dismissal of an indictment or complaint.
Right, so, or complaints. Let's say that a misdemeanor ADA failed to properly draft a misdemeanor complaint, and the judge throws out the misdemeanor complaint for facial insufficiency. Under the definition of misconduct in this FOIL request, that is misconduct, and that would require searching through all case files, emails, notes, personnel files, anything that could have been in the district attorney's.
So are you equating having to create some sort of an index to figure out what documents will be responsive with creating a document to be responsive?
Your Honor, that's part of our argument, but our argument doesn't turn on that, right? With our argument, the main thrust of our argument is that based on the way this request was framed, it did not reasonably describe a record within the meaning of the public officers law. It did not reasonably allow the FOIL the agency here, to locate the responsive records. And that's exactly what R.A.O. Yellen said in his determination letter.
Well, it says all records inclusive of, but not limited to, memorandum, notes, reports, emails, and notes.
Right. So what this means is that the agency has to go through every single case file, if your honors have noted, for every ADA who was employed by the office at a time during District Attorney Clark's tenure. So that could be an ADA who retired in 2017 and had been in the office for 35 years. You've got to go back 35 years, find all their notes, memoranda, case file, find out every time that they had a Batson challenge granted, anytime they had a case dismissed on speedy trial grounds, anytime they had a misdemeanor complaint dismissed for facial insufficiency. This would require absolutely Herculean efforts, which can fairly be described as impossible. This is not within the duty of an agency under FOIL.
Did you argue that it would require Herculean efforts?
Absolutely, Your Honor. If you look at R.A.O. Yellen's determination letter, he says very plainly, a response to your request would require review of every attorney's personnel file and making a legal determination as to whether it contains any information responsive to your request, as neither the Professional Responsibility Bureau nor Human Resources Department categorize their files by disposition or conclusion. I am thus unable to locate responsive records. And the RAO makes that determination after quoting the text of the FOIL request, and does that for number 54, and then the next page for 55 and 56.
But counsel, is that a defense that it's going to be hard, so we can't do it? That's not what the case law supports.
Well, Your Honor, the case law does say, this court has said that an agency is not required to engage in Herculean efforts. It says there's an office with a small FOIL unit, and these requests would basically require the entire resources of the civil litigation unit of the district attorney's office to be focused on Mr. Ostatcher's requests. And he has submitted not just the 3 in front of us today, but more than 90 of these requests. They're broad-ranging, they're repetitive. I'm not going to get into this, but there are reasons to infer that these are retaliatory requests based on personal grievances that the petitioner has against the office. And the FOIL law does not require the office to be subject to this sort of harassment.
Thank you, counsel.
Thank you.
Just briefly as to retaliation, these FOIL requests reveal that the DA's office destroyed evidence and case records in multiple homicide convictions and didn't tell anyone about it. There's one case being tried right now in the Bronx. Guy's been in jail
Counsel,
9
you
years.
can use the microphone.
Been in jail 9 years. Critical crimes that evidence was destroyed, they haven't told his attorney. So while they call this retaliatory, the Brady implications that these 4 requests have revealed are incredible.
So, counsel, that's outside of the record, and I don't know that that's something that we would even consider. So, in terms of your adversary's arguments you just set forth, how would you respond?
Very, very briefly, Judge. If these were overbroad when the DA's office got the requests, their FOIL request officer, access officer, is required to reach out to me, right? 21 New York City rules and regs Section 140.2, subsection B, 2 and 3, requires a FOIL records access officer to reach out to a requester if the request is overbroad or required too much effort. He never did it. All he did was refuse the request, which under Konigsberg, it's the bare allegation. So they don't answer that in their brief. This was brought up repeatedly. They don't deny it, they don't answer it. The second thing, he says in the access officer certification that he talks about not finding records in response to these requests. The certification is on page 185 and 186. That's the actual certification. What he's referring to was unsworn correspondence. In the certification, the DA's FOIL record access officer makes no reference to these FOIL requests or any search he conducted for these FOIL requests, in direct violation of Public Officers Law 89, subsection 3. Two more points very, very quickly. Their records access officer doesn't say who he spoke to determine how the DA's office keeps their records. They have a chief of their professional responsibility unit. They have a human resources office. Under Odone, when an agency keeps hidden, maintains an anonymous source as to a denial of access to records, that requires a hearing. In this case, a hearing is required. And this is my last point about changing my request and denying it because they don't maintain a list. You know, Civil Rights Law, Section 50A, was recently repealed. And it was done so to allow the public greater access to agencies' records of misconduct. If this court issues a decision saying that an agency can deny a request for records for misconduct because the agency makes a policy decision not to keep a list of records, you are going to see agencies all over the state saying, hey, let's not keep a list. And by doing so, we can then deny requests for records because we chose not to keep a list. It's a very, very dangerous precedent.
Thank you.
Thank you all.
Thank you both. Romero versus Valdez.
May it please the court. If a driver is able to switch lanes to avoid striking a disabled vehicle, it's not an emergency. The defendant knew this and told the court, swore under oath in an affidavit, that I was faced with an emergency and there were no other evasive maneuvers that I would have been able to avoid the subject accident when it occurred. I was unable to switch lanes as there were vehicles in the adjacent lane preventing me from doing so. That's what he represented to the court. And then this court held that that created an issue of fact because the defendant said, quote, he was traveling at approximately 45 to 50 miles an hour, that he braked hard to stop the van when it was apparent there was no room for him to merge safely in the middle lane as the Jeep ahead of him had done. And then 5 months later, after that decision, the defendant testifies at a deposition that
So,
I never
counsel,
even looked.
I was on that first panel, all right?
So
And,
you were misled.
Pardon?
So then you were one of the judges, yes,
I was one of the judges, yes.
that was
What
misled.
you said was that she was misled. And why would you say that?
Because the judge, the decision, and the court relied upon an affidavit stating that there was no way I could merge.
But counsel, you chose to file a motion for summary judgment before conducting discovery. Why is this not a second successive summary
I
judgment?
can't hear you, I'm sorry, Your Honor.
You chose to file a motion for summary judgment without first conducting discovery. Why is this not a second successive motion for summary judgment, which, as you know, is normally barred?
Okay. The answer, number one, is motions are made all the time prior to depositions. It is not only permitted, it is actually encouraged by the courts because we could resolve things before wasting time. Secondly, if after the depositions are conducted and after a motion for summary judgment is denied, it is then learned that the affidavit provided to your honors was false, I would hope that you would want to know about that and correct that.
Isn't that simply a question of credibility that's best resolved by the finder of fact?
I take depositions all the time, and people lie to me all the time. That's okay under oath. But when they submit an affidavit to the court on a motion for summary judgment, that's different. That's misleading the court.
Lying under oath is never good.
I'm sorry?
Lying under oath is never good. It's never okay.
Lying under oath is never right. Unfortunately, it happens too often. But lying to a
That's a different
judge
story.
is even worse, I think. So that's what happened here. Not only to the
Can
lower
you just
court.
tell us, how did he lie?
Well, let's take a look at his affidavit, the one that he submitted. Duly sworn, deposes and says. So what that means is he's
Counsel, we know what that means.
Okay.
Really? Like, we don't know what that means?
Well, then let me get to paragraph 7. I was faced with an emergency and there were no other evasive maneuvers. I was unable to switch lanes as there were vehicles in the adjacent lane preventing me from doing so. He swore that under oath. Now he testifies at a deposition. Actually, I had never even looked in the middle lane. How is that telling the truth? Because he clearly couldn't have said under oath that there were vehicles in the middle lane preventing him from merging in if he never bothered to look.
So your point is that this is something that's newly discovered based upon his deposition testimony?
That is exactly. I didn't know that. Your Honor didn't know that. We assumed that when he signed that affidavit that it was.
So this was not a successive motion for summary judgment, it was rather a motion to renew?
I made a motion to renew, Your Honor, and unfortunately the lower court in the decision said it was a motion to re-argue. That wasn't my motion. I made a motion to renew.
What normally happens when you have a transcript and an affidavit that conflict with each other? Isn't that something that you would question that witness about once they get on the stand and place their credibility before the jury?
If it goes to trial, of course I will. But the issue is right now, I made a motion, and that defendant represented to this court something that you relied upon and you stated in your decision to deny my relief. And 50 years ago, this court had a similar issue, where even after a trial was already done, it was learned that the plaintiff in that case had used an affidavit to mislead the court. And the First Department said, are you kidding me? No, we're going to reverse
Counsel,
that.
your argument is that based upon the deposition testimony, that's sufficient now for granting of summary judgment?
It is both. One, it should be a motion to renew, and two, successive motions are allowed when there's new information.
So my question is, are you arguing that this quote-unquote new information, this testimony in the deposition testimony now would be sufficient for granting of summary judgment?
It is sufficient for showing the court that, yes, because if he didn't, the answer is yes. Because
How?
Sure. You have to show for an emergency defense that there are no other evasive maneuvers, and that's discussed in all the opinions, including this opinion by the First Department in this case. And that's why he offered that affidavit, to show that there were no evasive maneuvers. But then you find out that, in fact, that testimony has no basis because he never even looked. So how did he ever defeat summary judgment? Because you have to have personal knowledge pursuant to 3212 to either oppose or to support it. If he didn't have personal knowledge to even know that there were vehicles in the middle lane, then he never met their burden to defeat plaintiff's prima facie entitlement to summary judgment on a rear-end collision.
Thank you.
Good afternoon, Your Honors. May it please the court.
Is the deposition testimony inconsistent with the affidavit?
Well, I don't believe so, Your Honor. What he testified to was that he did not look over his right shoulder. However, as a driver, you could be aware of moving traffic to the right of you or have a general sense that he couldn't move into the right lane.
In his deposition, he stated he did not look over his...
No, he did not, but I just want to direct the court's attention back to the emergency that he was faced with. because on the day of the accident, he was traveling behind a Jeep SUV, it was approximately 3 car lengths ahead of him, and he was traveling at or below the speed limit. That Jeep, suddenly, it didn't have an indicator on, it didn't have a brake light on, very fast, switched into the right lane. My client, Mr. Valdez, immediately put on his brakes. He kept his brakes applied, but despite that, his speed slowed and he struck the rear of the plaintiff's vehicle. Plaintiff's vehicle was disabled and completely dark. Now, if you read the entirety of Mr. Valdez's deposition testimony, excuse me, he said it again and again that he couldn't believe the maneuver that the Jeep SUV was able to make. He wasn't able to do so. That's what he said. Did he say clearly, I couldn't move into the right lane? He did not say that clearly. Would it have been better if he said something very clear? Yes, it would. However, that's an issue that really should be considered by at trial, and not on a motion, a plaintiff's motion for summary judgment on liability.
Did the trial court or the motion court correctly characterize this as a renewal or a new motion for summary judgment as opposed to a motion to renew and re-argue?
Well, the motion court did refer to it as a successive motion for summary judgment. And then also referred to case law, basically saying the same thing, that unless there's new evidence submitted on a motion to renew prior motion for summary judgment, then it's just it's successive, and the court found no additional evidence sufficient to grant the motion to renew, and then go to the merits of the motion for summary judgment.
In your position, in your view, would the emergency doctrine apply under either version, under what he
Yes.
stated?
Absolutely.
Okay. So the difference is
As a matter of
whether he
fact-
looked to the middle lane.
I'm sorry, Your Honor. What was
That's the sole difference, whether he looked into the middle lane and the fact that he omitted that in one portion, whether his credibility is at issue.
I think it's just a matter of credibility. If you read his deposition testimony, to me, it's striking. It's even more striking that it was an emergency. It could have been clearer in the affidavit that it was an emergency. It's unfortunate that there was a statement made in the affidavit that was maybe based upon his overall perception at the time, but that is a matter of credibility. And the plaintiff would have an opportunity when this proceeds to trial for the jury to hear that and to question him, and his credibility perhaps will be affected by that. Although, as I said, the deposition testimony of the plaintiff, Mr. Valdez, really shows that he was faced with an emergency situation. And it was not the defendant's motion for summary judgment, it was the plaintiff's motion.
Thank you.
Thank you, Your Honors.
It is not a credibility issue when this court is given a false affidavit. This isn't at a trial where we're talking about what he said or she said. This was given to this court. And if we want to encourage litigants to not use perjured affidavits, because if you do, you could just say, well, that's an issue for the court. This wasn't for the jury. This wasn't given to the jury. This was given to the court. And this court in the decision relied upon that. And there is no mincing of words, because if they wanted to put in another affidavit to explain what he said, they could have done that. And the only person, not appellate counsel, but the only person that offered any explanation for that, obviously, you can't have it both ways. If you didn't look, then you can't say that there were vehicles in the middle lane. The only person who offered an explanation is defense counsel in the underlying information. And you know what he said? He offered his medical opinion. He said that there was probably a memory issue. Really, is defense counsel now a neurologist? He doesn't know to get an affidavit from his client to even say that there was a memory issue, doesn't know to get an affidavit from a physician, doesn't know to even offer an explanation, doesn't know even to dispute that he committed fraud upon this court. Because you would think if your client was basically accused of committing perjury, that they would get their client and to sign a new affidavit and say, no, I didn't, this is the explanation, but they didn't do that. Not once. And they had an opportunity, and the only explanation is from defense counsel saying it was probably a memory issue. There's no memory issue, because if he testified in 2022 that there were no cars in the middle lane and that he never looked, then he certainly knew it 2 years earlier, right? That's not memory failure, that's memory improvement. So he knew it all the time. The only thing that he forgot is he forgot that he signed an affidavit to this court. That's what he forgot. Thank you, Your Honor.
Thank you. Thank you both. Jiang versus Ping An Insurance.
May it please the court, my name is Nicholas Herzler, and I represent the Huatai appellants in this matter. Your Honors, it's our position that the contract should be enforced because its language is unambiguous. The language of the contract clearly says that litigation can only be brought in China. Plaintiff does not offer any evidence to rebut
Well, it
that.
says the People's Court, right?
It says the it says the country where the, it specifically says the country, the exclusive jurisdiction for any disputes under this policy, the singular country for any dispute. And then the May 12th agreement clearly says.
County or country?
Country?
County or country? You're referring
Country.
to section 5.6 of the policy?
Right, so that's, yes, and then we look at you look at 252 and 218. So the parties, 218, the parties agree to submit to the exclusive jurisdiction of the Court of General Jurisdiction of the country where the policy was issued.
So item 8 of the schedule references worldwide, that the territorial scope and jurisdiction is worldwide, including USA and Canada. So how does one jibe with the other?
Because that's where the risks, that's where any occurrence happens worldwide would be covered under the policy. But what we're saying is that issued is defined at 252 of the record because it says what country is issued. It says issued China.
How do the closing slips play into or against your argument?
Well, there's only one agreement in the record.
Well, we have two closing slips.
There's only one in the record, Your Honor, and
There's only one in the record?
yes, if you look at
So
two,
we have a May closing slip, right?
And
And an
one.
April closing slip. So that's two.
the April one is not in the record. If it was in the record, we already proved with the emails that that was just an earlier draft of the final agreement. We submitted proof that the parties on April 29th had a preliminary draft of an agreement. Then they worked out the details, the kinks.
Who called this a preliminary draft? The closing slip, the one from April, did anybody say that that was preliminary or a draft or
Yes,
step
Jin-
1 as opposed to step 2? Because Mr. Jin
Yes.
said that it was a true copy of the closing slip. So was there any qualification as to its import, its meaning?
Well, again, that affidavit is not in the record, number one. Number two, he explains that they had emails that show where they negotiated from April 29th to May 12th. And so that final agreement.
Isn't that affirmation by Mr. Jin found at NICEF Docs 41 through 443?
I thought it was an attachment to the to his affidavit, the affirmation that was submitted to the court. Was it an attachment to one of the affirmation? The April closing slip?
It was an attachment. It was not an attachment. It was referred to by the NICEF citation by plaintiff in their opposition papers. But even if the court were to look at that, even though it's not in the record, we proved with all these emails that there was an earlier draft. And that, by the way, that April draft, if the court looks at it, it's not signed by all the parties.
Okay, so even assuming, well, that's the question. So you're saying that the May closing slip, therefore, is what?
It's the only contract in the record that's signed by all the parties. It post dates by 2 weeks the preliminary draft. So they have an agreement that's everybody's signed. They don't dispute the signatures. We have a contract.
But there are references to the April closing slip as being the final draft, the final.
No, he just says these are documents that were in my file. I found this document, a pre-answer.
That's a little bit more than that. They were true and accurate.
They are true and accurate. He had documents in
and
his
the emails that you're referring to, you're sort of saying very forcefully that they indicate that the May slip replaced or was the final version of the April slip, but it doesn't say that in the emails.
The emails talk about why they had changed the agreement, which even plaintiff alleges that they had to switch Huatai in place of Ping An as the other co-insurer. So the emails talk about that too. So they had a preliminary draft.
The fact that there's an affirmation or a swearing or putting forward to the court that both the April slip and the May slip are true and accurate, doesn't that in and of itself present an issue of fact?
No, because they're both true and accurate documents, just that one was a preliminary agreement and the second one was fully signed.
Well, one talks about jurisdiction and the other one is silent, which is the smoking gun here.
But we have First Department precedent that says that the only thing that matters is the final agreement. And here we have a final agreement.
And then we go back to the circular argument where your emails don't establish that that's the final version.
They do establish that because they talk about how they had a draft and then they had to change it.
We'll see what your adversary says, and I think they beg to differ.
Thank you.
May it please the court. I'm Rishi Bhandari from Mandel Bhandari, and I represent the respondent.
Well, let's start with that. The May slip, was that the final version of the April slip?
No, it's not the final version. It's just a completely different document. The document that was filed and attached to an affidavit from somebody from Huatai named Eric Jin.
That's the April slip, right?
Yes, exactly.
Okay.
So that was he filed it as NYSCEF document 441 was his affidavit. If you look at his, he says it specifically, sorry, my foot is a little bit injured. Grab this. In that paragraph, 441, in paragraph 7 of, so this is NYSCEF 441. This is the affidavit from Mr. Jin. In paragraph 7, he says, true and correct copies of the CNET policy for the second year in Chinese and English version are attached hereto respectively as Exhibit A and Exhibit A1. He does not say these are preliminary agreements. He did not say, as my adversary said a few moments ago, these are just true and correct copies of documents from my file. He did not say those words, and that's critically important. What he does say over here is true and correct copies of the policy for the second year and Chinese and English version are attached hereto. That's very different than saying what are attached are just things from my file. It's very different than saying preliminary agreements. The second thing you heard from my adversary is that the document that was attached to Mr. Jin's affidavit in 2017 was not signed. That's also incorrect. If you look at plaintiffs, if you look at NYSCEF document 443, Exhibit A1, and you go to page 18 of this document, 17, you see that it is signed by an authorized signatory. The next page, page 18, is signed by an authorized signatory. In fact, every page from 18 onwards is signed by an authorized signatory until the very last page, which is page 48, signed by an authorized signatory. So you've heard two things from my adversary that are both false. And those are reasons why Justice Maisley said, there is no possible way I can grant you summary judgment where you say some email correspondence that was not certified in English, the Chinese translations of those, based on some email correspondence, and what you're deciding to say today to me in this court that contradicts what your representative said on two prior occasions is undisputably true. Now, the fact of the matter is, if you actually looked at the most recent closing slip that they submitted, it's not even a closing slip. It's called a quotation. What they actually did is they just simply appended another document that they wanted to add to this in order to try and bolster their claim that that this policy was issued in China and therefore it should be heard in China.
Has discovery been concluded? Have all the depositions been concluded?
Yes, discovery is concluded on March 22nd. We filed the note of issue in this case.
And so all depositions have been taken because, was it Jianming, his deposition had not yet been conducted?
Yeah, he refused to come to the United States for his deposition. Justice Maisley repeatedly issued orders saying either come to the United States for your deposition or show me reasons why you're not allowed to travel from China. They changed their story multiple times. First, they said it's because of quarantine. Then we found news reports saying that it is possible to, in fact, apply during the time period when Justice Maisley gave them permission to do so. Then they said we went to the American Embassy, and the American Embassy denied us a visa. And then we got the slip from the American Embassy, and that slip actually said, this is not a denial. Please come back within a week with the following documents and a fee to pay. And then they said, well, that would be pointless. What we've heard is that if you go back, they always say no. But they've made, so when they presented, and then finally they said he can't actually fly all the way to the United States. He has a medical condition.
So did he ultimately come?
He never came.
He was never
So
deposed?
Justice Maisley said, you know what? Fine, he didn't come. He's not going to be able to testify at this trial. He can't fly here for trial, but refused to fly here for depositions. So they produced an 11F witness, a person named George Mason. And that George Mason person testified unequivocally. Their corporate representative testified unequivocally. There are no exclusions that apply to the tender of the claim based on the incident from the SEC in 2011. Basically, this case is teed up for summary judgment from our end. They're not entitled to a successive motion for summary judgment. They had their shot. They chose to make it early. It would have been denied in any event whenever they decided to make it, but they certainly aren't entitled to a second bite at the apple on summary judgment when they decided to make it based on a clear record that contradicted their position.
Thank you.
Thank you.
Your Honors, my adversary just talked at length for a long time about a lot of things that are not in the record on appeal. It was my understanding that the court's rules are very clear that only the matters in the record on appeal can be considered. He talked about
My
that.
only question was whether depositions have been completed, whether discovery had been completed, and the answer was yes. And so that's all that's considered.
Your Honor, if we look at 252 and 253 of the record, we see a signed agreement by all the parties that postdates the April 29th agreement. So I just don't understand why, even if there was some other document, a preliminary, any kind of other version of a contract in the record, how does that matter when we have a signed agreement by all the parties? They're not contesting the signatures. They're not contesting that it says policy issuance, Shanghai People's Republic of China. That's what the parties agreed to. So since they agreed to that, what difference does it make that they want to bring in somebody for a deposition? How can he change the language of the agreement? And his affidavit, the purpose of it was to authenticate the document. That's what he did. And so even if even if the April 29th document was fully executed, which it's not, it's only signed by Huatai, and it's outside the record. So I don't know why the court is considering it. But even if the court did look at it, it doesn't contradict the fact that on May 12th, the parties signed an agreement that absolutely unequivocally says, in no uncertain terms, policy issuance, China, which makes perfect sense because we know that all three parties, and they don't dispute this, all the parties to the agreement were all in China. So doesn't it make sense that they would all agree that this is the most convenient place for them to litigate any dispute? So I just don't understand why they would even be able to claim that the April 29th agreement has any relevance or that they would be able to ask questions at a deposition about it because this court's precedents are clear, as we cited in our brief, that an earlier draft of an agreement does not raise a question of fact. Thank you for listening.
Thank you. Thank you both. Maldonado versus Rupert Housing.
Good afternoon, Your Honors. Seth Weinberg with Mara Lillian, the party for the defendant appellants. And we believe summary judgment was improperly denied for two reasons. First, in this case, plaintiff was behind a locked door with a peephole that was functioning. And as the cases in our brief point out,
So the testimony was that plaintiff had informed the security management, et cetera, that this gentleman was not to enter the building. It was not to be allowed to come up to the apartment. Is that correct?
that's correct.
And so at some point in time, I think it's Ms. Gomez, she contacts plaintiff and says that he's on his way up, right, to retrieve his belongings or something of that nature?
Ms. Gomez testified she called the apartment and no one answered.
No one answered. And so then she directs was it a walking guard, Vinny Acevedo, to escort Mr. Payton up to the apartment, right?
Correct.
And then according to plaintiffs, someone rings the bell or what have you, and they see the walking guard as well as Mr. Payton outside the door.
I don't know but they claim they were aware that Mr. Payton
right,
was
and
there.
and apparently because they see the walking guard, they see someone with Mr. Payton, they open the door, but lo and behold, once they open the door, the walking guard, Mr. Acevedo, is no longer present, and it's just Mr. Payton, and then he rushes in and he assaults the plaintiff. So then the question becomes, at the point where Mr. Acevedo escorts Mr. Payton up to the apartment, should not Mr. Acevedo have remained with Mr. Payton while Mr. Payton went into the apartment to retrieve his belongings, et cetera?
2 points, one direct, one not direct. So I'll start with the direct first, Your Honor. That was basically the Flynn case where the guard negligently let up the assailant and the plaintiff opened the door and an incident occurred. So I don't think it makes a difference from that perspective. The less direct answer is at deposition, Plaintiff Torres testified he opened the door to give the gentleman his clothes. He never said, I did it because Mr. Acevedo was there. That came out in post-depositions affidavits from Plaintiff Torres and Plaintiff Maldonado, or former Plaintiff Maldonado, and we would submit former Plaintiff Maldonado's affidavit should not be considered. She refused to appear at depositions. That's why her complaint was struck. It would seem contrary to the rules or contrary to the spirit of the rules to allow someone who refused to comply with discovery to the point of having their action struck to be allowed to submit an affidavit to raise a question of fact for somebody else.
Well, that's the issue, right? So are there questions or factors? Is there a question of fact as to whether or not your client's employees, by one, even allowing Mr. Payton to go upstairs, even in the accompaniment of Mr. Acevedo, and then Mr. Acevedo leaving Mr. Payton at the door, whether that was the proximate cause of the injuries to, is it Mr. Maldonado, Mr. Torres, right?
Not based on the case law cited in this brief, cases like Van Loo, Benitez, Flynn, where an intruder, assailant, circumstances are different for each one, made it to the apartment door where there was a lock and the plaintiff opened the door. And in each one of those cases, this court held summary judgment for the defendant.
Right, but
was
then
granted.
we have subsequent case law to that Benitez case and the ones you cited. In 2001, for instance, this court held that that was in fact a question of fact underneath the Mason case because of the circumstances of how that person got up to the apartment.
I'm not familiar with the Mason case, Your Honor, but I do know Flynn was 2010, so that would post-date the 2001 decision. And in that case, again, a guard negligently let the assailant upstairs to a plaintiff who was behind a locked door, and this court held that that's a targeted attack and it severs the causal connection. So I think one could perhaps say there's a question of fact as to why the door was open, but I think at the end of the day, from a proximate cause perspective, based on the case law, it doesn't matter. There was a working door, working lock.
Right, but the circumstances, this wasn't just letting the person up. This was escorting the person up and then leaving that person there, right? So it's a little bit different. That the question of fact would be, well, why was the door open? And maybe that will come out at trial because they thought they were being escorted up.
We would
That's what
submit.
they observed, right?
I apologize, Your Honor. I didn't mean to cut you
Go
off.
ahead.
We would submit that should have been his answer at deposition. I did it because the guard was there, not I did it because I wanted to get this over with and get his clothes out of here. And then perhaps why it came out in affidavit later, and you shouldn't be able to do that. But beyond that, I would say, like Flynn, this is a person who was in the building routinely for a period of time before this incident, without incident, same in Flynn. And the only really distinction between the two is letting the person up. But I would say in this
I
case,
thought there had been an incident, an alleged incident between Mr. Payton and Ms. Maldonado.
inside the apartment,
Which was what led to this whole, the issue, and which led to the barring of Mr. Payton from the, from the building and the apartment.
that's exactly where I was going to go next, Your Honor. So the point is, there's nothing in the Flynn decision to indicate that plaintiff knew his ex-girlfriend was going to do something horrendous when he opened the door. In this case, these plaintiffs knew they had an incident with the person, to a point where at one point they said, don't let him in the building unless the police are here, and yet they still chose to open the door. So they were perhaps more incentivized than the Flynn plaintiff was.
The flip
not
side
open the
to that
door.
argument is that they felt comfortable in opening the door because Mr. Acevedo, who was the walking guard, was present.
Again, Your Honor, that doesn't come up until the affidavit post-EBT. Thank you.
Thank you.
May it please the court.
So, counsel, what's your take on what's the Flynn case and how it is applicable or inapplicable to the facts here?
I apologize for delaying in answering your question by prefacing it with, I'm very disappointed that every time I come here, the court asks questions identifying all of my points and steals my thunder.
We'll try to do better the next time.
The Flynn decision was decided by an extremely wise court. I don't remember which department. Maybe it was the first department. And at least 3 times in the Flynn decision, this court identified that, yeah, there's this prior relationship, but there's nothing whatsoever in the entirety of the record on Flynn to suggest that the plaintiff warned the building that this guy should no longer be admitted. That's a pretty significant distinction. 3 times this court mentioned that in the Flynn decision. In this case, we don't have a suggestion. We don't have a, well, maybe they could tell he was dangerous. We have an admission that they were told repeatedly that this guy was dangerous and he should not be admitted. Furthermore, we have prior attempts to get into the building, which were met with a simple no from the security guards, and the assailant did not jimmy a lock. He did not turn into a ninja and assassinate the plaintiff. He left. And so the question here is not, is there some case where a targeted attack deprives a plaintiff of causation against a defendant? Of course there are cases where that could be the case, but this isn't one of them. This is not passive negligence getting around a jimmied door or a defective security camera. They actually were told not to bring him in, so they sent him in. And not only did they send him in, they bring him to the door, they ring the bell, they say, hi, we are here with this guy. The only testimony is that the conversation at the door on the moment of this attack was with the security guard, Mr. Acevedo, who then left without announcing his departure.
Your adversary suggests that particular issue might arise out of a post-deposition EBT and it shouldn't be considered?
So the testimony from every witness is that they knew the guard was there, and he says in his deposition testimony, I don't know what happened to the guy. I mean, I would have waited. I don't know where the guy went. And the suggestion that he opened the door to give him his clothes, let me ask you this. Would he have opened the door if it hadn't been a doorbell rung by Mr. Acevedo? Would he have opened the door if the defendants hadn't put him in that situation, lulled him into a false sense of security? So as going all the way back to the earliest Court of Appeals decisions, if the defendant's conduct puts us in more danger than we would have been had they done nothing, then there's a question of fact as to their negligence being a proximate cause. Here, we would never open the door to this assailant who had threatened us, who we repeatedly told them not to let in. We wouldn't do it. But because Mr. Acevedo is there and says, hi, I'm here, and then leaves before we have a chance to even address the situation, and then we open the door and lo and behold, he's gone.
So there's a section of the incident report prepared by Ms. Gomez.
Yes.
That I'm just looking at now, where she acknowledges that the tenant from 29K called to say, do not let this person up. And then subsequently, the person came back, said he wanted to go up, back and forth, back and forth. And Ms. Gomez says, I was told he could come back in the morning, not by the actual tenant, but by her partner.
Right.
Who was not the tenant of the apartment. And at the point where there's no answer at 7:30 in the morning, that's when the walking guard, Vinny, goes upstairs, Mr. Acevedo, right?
Correct.
So I'm looking at the portion here where it says, Ms. Gomez says, no one answered, and Miles needed his clothes. I believe he uses two names. And so I asked Vinny to go upstairs with him. Vinny went and came back down. 29K, and I believe that's the apartment in question, called on the landline and said, and told me, if anything happens, it is on me. So how does that play into your argument and your adversary's defense?
So in the context of a summary judgment motion, the unsupported by anything other than her self-serving incident report after an incident had already occurred, after threats of calling the police had already occurred, by a party defendant witness that she didn't do it wrong, is not controlling. What is controlling is the repeated testimony of my client that they never would have given this guy permission to come up without the police being present, and that they didn't that morning.
And that portion that was just read, that was what occurred after the alleged altercation.
According to the incident report, again, which was issued
According
by...
to Ms. Gomez's incident report, that is what occurred after, where she called up and they said it's on you, and they called the police, and then she went upstairs.
Correct.
Thank you.
Just briefly, Your Honors, I'd like to address my colleague's answer to Justice Burke's question about the deposition testimony. He gave a lot of rhetorical questions as to why someone wouldn't open the door, but at no point did he say, yes, Mr. Torres opened the door because the guard was there, and here's where he testified to that. That testimony is just not here, and at this point, we can make a lot of assumptions as to why he opened the door. But if it was truly, well, there was a guard there, he could have said that. Instead, he specifically said, I wanted to get this over with and give the man his clothes.
But he did testify, did he not, that when someone rang the bell, he did look through the people and he did see Mr. Acevedo and Mr. Payton, right?
I just don't recall the C part. Again, like I said before, I know he knew Mr. Acevedo was there. At the time the
Saw
bell was
Vinny
rang.
Acevedo and Payton.
I'm not disputing he believed Mr. Acevedo was there. I just don't recall if it was seen versus he heard the voice. That's just, I don't recall from the record.
I'm just...
Okay, it says saw, but okay. But even so, again, why does not lead to some type of issue as to whether or not that's why he opened the door? He opened the door because he saw both Mr. Acevedo as well as Mr. Payton, as opposed to just seeing Mr. Payton.
Because when he was asked, that wasn't what he said. When he was asked, he said, I wanted to just get this person out. And if, like I said before, if you have this person persistently coming to the door, and yes, he was turned away, and yes, he left, but the point is he came back multiple times to try to get up to this apartment. So really the only question was not if he was going to encounter plaintiffs, but when. And at that point, that's a targeted attack to which proximate cause is severed.
But I thought he was supposed to only go up to the apartment with police. That, the police had to be present. The police should have been present. But anyhow, I'm sorry. Go ahead.
Yeah, the more answers you give, the more reasons I see for having a trial. Frankly, there's so many issues of fact. There's so many credibility questions that are raised in my mind that I don't see how this can be decided on paper.
My only answer to that, Your Honor, and it's, I guess, a good thing the red light is on, is we believe the case law on proximate cause is controlling. So regardless of the facts as to why the door was opened, et cetera, the law on targeted attack and opening a locked door is what we would say is controlling.
Thank you.
Thank you.
Both. Sonashine and 477 Willis Avenue, LLC versus 1986 F&S of New York Limited and New York Deferred Exchange Corporation, which just took up your 1 minute, right?
Thank you, Your Honors. May it please the Court, my name is Ethan Cohen from Rosenberg and Estes, representing the defendant respondent. I'd like to note the appellants have not appeared. They have not submitted a reply brief, so all of respondents' arguments that have been submitted to the Court are unopposed and undisputed. I would ask if the Court has any questions about this appeal. Otherwise, I would submit on the briefs.
Thank you.
Thank you, Your Honors.
Excellent. Only 40 minutes 40 seconds, rather. People versus Robert Hammond.
Good afternoon. I'm Catherine Martone on behalf of Mr. Hammond. I'd like to address our claim that the court erred in summarily denying his motion to suppress his alleged statement. Under CPL 71060.
So why would that not be pedigree information? Sorry?
I wanted her to lower the mic instead of raising it.
Oh, I heard her. But anyhow, why would that not constitute pedigree information?
That's a question that would have to be determined after a hearing in light of appellant's papers, which alleged that his statement was involuntary. Under CPL 71060, when a defendant, a denial of a hearing is only authorized when a defendant's papers do not allege a ground constituting a legal basis.
But the people, so then the people respond by saying these were not statements pursuant to 71031A, right? But rather, these were purely questions of pedigree, name, address, et cetera.
Right.
So I'm not, again, there's nothing that says there has to be a hearing if on the papers it can be determined that it was pedigree as opposed to some type of custodial interrogation.
I would say, Your Honor, that that you're not right about a couple of pieces of that. The statute is clear, and the Court of Appeals authority in People v. Weaver is also clear. This, first of all, to go back one step, their VDF asserted that the statements were pedigree. And in response, having received the VDF, the defendant's motion alleged that his statements were involuntary. Under the statute, the court was then required to hold a hearing, regardless of the nature of the factual allegations that supported the claim. That's clear from the Court of Appeals' holding in People v. Weaver.
People v. Weaver says that you have to hold a hearing?
Yes, it does. It says,
really?
Expressly provides that the absence of factual basis does not permit denial of a motion to suppress a statement claimed to have been involuntarily made to a law enforcement official. There must be a hearing whenever defendant claims that his statement was involuntary, no matter what facts he puts forth in support of that claim. So a hearing was required.
That is totally different from where we're talking about statements pursuant to CPL section 71031A, which are custodial, which is the pursuant of custodial interrogation, as opposed to pure pedigree information.
Well, Your Honor, we would have to, the question before the court at the hearing would be the circumstances under which the statements were elicited. And as the Court of Appeals set forth the standard in People v. Wortham, the hearing court would have to determine whether the questioning was in fact pedigree questioning, or whether the questions were made under the cover or to cover up what was actually.
Let me ask you this question, because it's my understanding that the statements that were made were the information to be suppressed was his name, his date of birth, his address, things of that nature, right? Is your position maybe that because the crimes for which he was a suspect was related to identity and identity theft, that those particular statements were involuntary because there was no, even if they were name, address, date of birth?
That's exactly it, Your Honor, because.
Okay, so your argument is not that automatically there has to be a hearing based upon the request for a hearing and then the people coming back and saying, it's pedigree. You're not saying that. You're not saying, in other words, that the Court of Appeals has stated in People v. Weaver that there has to be a hearing, right?
I'm saying that under the statute, yes, Your Honor, I am saying that, and that's the reason why there has to be a hearing, just because it was his name, his address, his, and they said including information like that, so we don't know the full extent of it. just because it was that type of information doesn't mean it was entitled to the pedigree exception.
But again, as my colleague,
Miranda warning.
asked you, is that based upon the charges here, or is that in every case there would have to be a
Well, that's
hearing where the
certainly
people are
one.
asserting its pedigree?
That's certainly why in this case, we would have a claim, potentially.
Thank you. So, counsel, I just want to be clear. Is that what Weaver said? Because I've never read Weaver to say that.
Your Honor, I don't believe Weaver says that. Weaver, I don't believe, deals with a pedigree statement at all.
No, I don't think so either.
In addition, Wortham and Rodney and cases like this do not lay out a requirement that a hearing must be held for a pedigree statement.
Well, counsel, what about this fact that upon the police's arrival, they know that he's suspected of identity theft, and then they ask him specific questions about his identity, which, if answered in a certain way, would be indicative that maybe he was in fact the suspect that they were looking for. So why is that not outside of pedigree under these circumstances?
Even under these circumstances, Your Honor, the Court of Appeals is clear, including in Wortham, which is cited in both briefs in this case, that the police have a right to know who they have arrested. The VDF that the people submitted in this case stated defendant provided pedigree information, including his name, date of birth, and address. That's the only statement that was noticed. And Rodney also makes clear that it actually didn't have to be noticed. Rodney is the Court of Appeals case where there actually wasn't a hearing, and the people were able to use a pedigree statement, the one about the defendant saying he was in
Because
sales.
Rodney says, my recollection of Rodney is that you don't have to give notice of pedigree information.
Yes, no, Your Honor, that is absolutely correct. Rodney says that these statements are not subject to suppression, and they go further than that and say that because they're not subject to suppression, the people are not required to
So
provide
given
notice.
the fact we're talking about identity theft in that he is alleged to have tried to, is this the one he was trying to cash? Oh, the debit card, right?
Yes.
Someone else's name. Given that fact then, would not his name, address, and date of birth possibly go to the crime itself, and therefore there should be a hearing as to the suppression of any statements made as to his name, address, and date of birth?
We would say no, Your Honor, because the case law following Rodney is also very clear that even in cases where some of the evidence can be perceived to be incriminating, as long as the statement is related to the administrative requirements of the police, and in this case, obviously, knowing who you've put under arrest is a very important requirement. There are cases, People v. Aline, People v. Velasquez from this court, that say that even in these circumstances where it might end up yielding incriminating information, as long as it wasn't designed as an investigative inquiry, then it would still be covered by the pedigree exception.
Could he decline to give that information to the police upon arrest?
I guess he could decline, sure. I mean, I think that I'm sure defendants do decline. I'm not, obviously that didn't happen here.
But that's not without consequence, right?
I believe it is not, Your Honor. It's been a while since I've litigated these kinds of cases. I think there's false personation if you give the wrong information. There are statutes, I believe, that would address that situation.
So that would mean really in cases involving identity theft that those statements would always have to be noticed and they would always be subject to a hearing, right?
You're saying, I'm sorry, what would mean that? I apologize. Your Honor.
Pedigree information. In cases involving identity theft, whenever the police asked as to your name, your address, your date of birth, since it may be pertinent to the crime of identity theft, it would have to be noticed. So you really technically would never have pedigree information, right?
I guess, I mean, Your Honor, my reading of Rodney is that it doesn't have to be noticed, but that it could still be used as evidence, in other words. May I just briefly say, our position is obviously that the suppression arguments are foreclosed by the valid waiver of appeal. But in any event, the court's decisions in suppression were proper. I'm happy to answer any other questions that your honors may have.
Thank you, thank you.
If I could just quickly address the waiver of appeal. To be valid or to be effective, the record has to demonstrate that the defendant had a full understanding of the consequences of his waiver. And both the plea court's statements and the waiver form misstated the nature of the right.
So we have an oral waiver and we also have a written waiver, is that right?
Yes, and both misstated the scope of the right, misstated the scope of the waiver.
The written waiver did?
Yes, so the written waiver indicated that the defendant was also waiving his right to challenge the voluntariness of his plea, which is something a defendant always retains. So this is not a case where the written waiver clarified or amplified, supplemented what the court said. This is a case where both the court's statements and the waiver were incorrect. And so you can't infer from this record that the defendant understood the nature of the right he was waiving.
Thank you. Pentagon Federal Credit versus Popovic.
May I begin?
Please.
Thank you. May it please the court, Brett Berman from Fox Rothschild on behalf of the appellant. What we have here is a prematurely denied or prematurely granted summary judgment motion. Let me correct myself. The issues that were improperly granted on summary judgment prior to the close of discovery deals first with the impossibility, frustration of purpose defenses. This case, and I'm aware of no case by the First Department at this point that has addressed the taxi industry and the impacts of COVID. I am aware of cases that the First Department has dealt with other industries, such as restaurants, leases, et cetera. This is different than those cases, and that's really the point that has not been addressed yet by the appellate courts, at least by the First Department.
Well, let me just ask you this question before you jump into that. Was there an executive order directed at taxis saying that they needed to shut down, or were they deemed essential?
So the answer to that question is the record is barren on this point, right? So what you have argued to the lower court, Justice Barak, was that there was an executive order that allowed taxis to be essential service providers in the general sense. That's not what we have here, right? This is a management company relationship where you have dispatchers and fleets and lots of different things that were not addressed by the record. And that's one of the points that was not addressed by the lower court in discovery. Who was it that was allowed to operate taxi cabs? Was it the driver? Was it a fleet? Who was exempt and who was non-exempt, right? And that's a fundamental barrenness in the record with respect to what would be operating, who would be the people that would be operating the vehicles, and what specifically in the executive order allowed taxi cabs in the general sense to operate with no business, by the way, and no customers and nothing that would actually happen here. And that's the problem, right?
So you're saying that no individual taxi cab driver was hurt by this denial by the court, right? I mean, sorry, granting by the court of the motion for summary judgment.
Your question was no individual taxi
Right, you're
cab
saying
driver?
that the only individual at issue is a lender that finances the purchase of taxi cab medallions, but no taxi cab drivers, no taxi cab, well, this would be, no taxi cab owners were hurt.
I don't think that's what the record says. What I think the record is that these medallions pursuant to an order without discovery on factual disputes allowed for the seizure of medallions that are sitting not operating on the shelf. So to argue that, I think what you're saying is that a taxi driver who then can't operate a medallion that's no longer being operated in the city of New York as a result of this conduct wasn't hurt is, again, something not within the record. So maybe I didn't fully understand your question.
Well, you brought up other cases where we've said that notwithstanding the fact that a restaurant was shut down or a store was shut down, notwithstanding the loss of income, or I should say revenue, that there was no redress available unless the contract so provided for this type of
Unless the
situation.
contract I'm sorry.
Right, and here, taxi cab drivers were allowed to continue in operation because they fell into the exemption of essential drivers. So that's, for me, that's kind of important, but you're saying it's really not important because there weren't individuals affected, it was just a lender.
No, I think that somewhat confuses the issue and kind of addresses my point that the record is barren and no record exists on this point.
Did you actually make the argument that although they were considered essential, that there should have been some type of discovery or some type of further investigation, I guess, or exploration as to whether or not these individuals were actually able to go to the I forgot where they keep the cabs, to go there, to actually drive, that type of thing? Did you actually make that argument
Yes,
before Judge
this
Barak?
came up before Justice Barak, an argument where I also argued, because he raised the question just like this court has, they're exempt, right? This was an exemption under the executive order. And what I said was, you're only looking at one portion of the exemption. I don't remember my exact words. I don't like quoting
Because
arguments.
he said, my recollection is you're essential, and said therefore it wouldn't cover.
But that's the fundamental problem. This is not a driver issue, right? These are not drivers of taxi cabs. These are owners of taxi cabs that lease to a medallion leasing company. There is a statutory scheme from the TLC. This did come up with Justice Barak.
But counsel, I know we strayed off the main issue. Regardless, you do concede, or you do recognize the fact that we have a loan, we have loan repayment, and there's a default on the loan, right?
A default.
Seven loans, right? A default on 7 loans.
A default caused by COVID, right? And that is an impossibility frustration defense because there is not an apportionment of risk on this issue. And again, the difference, and I just have to say this and then I'll move on, with the restaurant cases, which I've litigated myself, right? One of the fundamental issues on restaurant cases or leases was that they could operate and do other business.
Right, so we had restaurants, so you could open the little shed out on the sidewalk. We had the Valentino case, we had the Gap case.
You could sell online, you could do other business.
You could sell online, you could do curbside pickup. We have all of those cases, and we said there was no issue in terms of frustration, right, or possibility in those cases. And I recognize your argument, and it's different with
because, and let me just get the one because in, and I did, this is in the briefs. First of those, there's a lot of different reasons. The first department, second department, and other departments addressed those cases in the way they did and reasoned in the way they did. The difference here, and we put this in the papers, is that there was no relief program for this industry in the way that it was for all of those industries. They were not subject to the same programs that the others were.
But this industry was never shut down.
It was shut down. It absolutely was.
Because ridership waned, not because anyone told them to shut down.
No, and this is why I said the record is barren on this point. Who was it that was exempt? That is the issue. These are not drivers. This is not an owner-operated vehicle, and this is what I argued to Justice Barak. If we were talking about medallions that were individual owner-operated vehicles, that's one thing. That is not these. These are corporate medallions. Corporate medallions cannot be operated by a person who owns them in the same manner an individual operated medallion can. They need to be given to a leasing company. Where in the record is any of this addressed in any way whatsoever about whether or not these medallions can operate? Justice Barak respectfully jumped to the conclusion that this is an individual owner-operator medallion. That's a different story under a different statutory scheme. And that's why this record has nothing on that point, other than to simply make the general comment that the executive order exempted everyone in the industry. The mechanics, I don't know how a car is being operated without the mechanics. Are they exempt? Were the lease operators fully exempted the same way?
You're arguing against yourself, aren't you? That everybody was able to operate.
I'm saying they couldn't operate. That's the difference. This is not an individual owner-operated medallion. These are corporate leased medallions. It is a different issue subject to TLC regulation.
So you're saying that although they were essential and therefore they could operate, you don't know whether the ancillary individuals, employees, the mechanics, the leasing companies, whether they were able to operate because they were not essential, and therefore whether the cabs could in fact run?
Because the way that these type of medallions get payments to pay the end result user here, the loan, comes from a management company who needs to actually make the payment because of all of those other services, right? That's the difference. When you're talking—
And I saw nothing referring to that in the record. I saw nothing in response to a plaintiff's motion for summary judgment I saw nothing which would counter that, saying, well, you know what, we were essential, but X, Y, and Z, the arguments you're just making.
Well, again, I don't agree on that, respectfully, Judge, because this exact issue came up because of the position taken by PenFed that the executive order exempted the entire industry from all ability to operate. That was the statement in the summary judgment record, and that's why Justice Brock and I spent a lot of time on this issue.
Well, that's what I'm saying. I didn't see anything in opposition to that by saying, yes, they were essential. However, in actuality, again, they were not. They could not operate.
Well, the difference is that what we did do in the Sophia Popovich affidavit is lay out why there couldn't be payments made, because they were not receiving payments from the leasing company because that was not operational. That's the way it came up. But again, they were
not operational because there was no ridership.
Because there was no ridership, and because
that issue of no ridership, is that something that's guaranteed in these medallion loans, that there will be some level of ridership, some level of profitability?
Well, it's not about the profitability. That's not what I'm arguing here. I understand this court's decisions in other cases involving loans. This is about whether or not an industry was different than the rest because they were not subject to the same requirements, and that, yes, in fact, was the leasing company able to move forward or not move forward to be able to pay here?
I kind of understand, but as my colleague just said, ridership is a totally different issue because the executive order or what have you did not say that you couldn't take a cab. It didn't say you couldn't take cab, Uber, or Lyft.
Sure.
That was up to the individuals in the community. Individuals may not have wanted to take a cab because of COVID, but that had nothing to do with the executive order.
Again, I think we're highlighting points that you have no record to even talk about. I don't mean you can't. You could ask me whatever you want, of course, but I mean there is no record on this. So in fact, if we're going to take that argument further, well, let's talk about how taxis in New York actually generate primary revenue. And again, this isn't our argument, but I'm just going to respond to you, which is airports, trains, and business travelers. That wasn't here.
See, the problem, again, as my colleague was saying, ridership is one thing, and that has nothing to do with the executive order or your being.
You're absolutely right, which is why I'm not focusing on that argument, because again, I understand what the First Department has done on other types of industries. I think this is unique for the reasons set forth in our brief, but more importantly, this is a barren record on summary judgment, and that is the fundamental problem. I'm not saying win or lose at the end of the day. That's for a different day. What we're talking about here is a record that is insufficient to grant summary judgment as a matter of law on impossibility, frustration of purpose, and factual-based offenses and counterclaims. That is the issue.
Thank you.
Thank you, Your Honor.
May it please the court, Daniel Green of Vetter Price for the respondent. I think the court is correct here that there is not a substantiating record supporting most of the arguments that the appellant's counsel is currently making, because this is an argument that was largely introduced for the first time today. There are perhaps a sentence or two devoted to it in the reply.
It was mentioned before Judge Barak. This particular argument was also mentioned.
But the record is largely devoid of support, and these are points in which the necessary support would in fact come from the appellants. There was nothing precluding the appellants from further developing a record on these points. They opted not to do so. But taking a step back, these do not support an impossibility defense. These are instead business challenges. They are not unlike the challenges that the industry encountered during the rise of rideshare apps. These agreements clearly allocate responsibility for business challenges to the appellants. We did not force the appellants to borrow money from us. They came to us and sought money, and they opted to invest that money in taxi medallions. And that brings us to a further point, a distinction which was touched on by opposing counsel, and I think the court noted as well, which is that this case is unlike some of the precedent we've seen come out of cases where loans or installment sales were implicated and that have generated a case law relating to the defense of impossibility. Here, the contract, it's a loan. It's a loan for money. We did not lease property to the appellants, which was then destroyed.
Are you talking about destruction of the subject matter?
Exactly. We lent them money, and they had an absolute obligation to repay that money. The fact that their ability to generate income from the collateral that secured those loans is immaterial to the actual contract between us. These are commercial entities, deep-pocketed individuals who chose to borrow in excess of $10 million from us. Presumably, they have other income streams and investments that they could use to repay those obligations in the event that they encountered business challenges in the operation of the taxi cab medallions. And if the court has no questions for me, I will rest.
Thank you.
Just briefly, a few points, as we didn't get to the other arguments, and I won't belabor it, but when there was a lot of talk here about we borrowed the money from them, we didn't borrow the money from them. Who did we borrow the money from? From an entity that was taken over by the government because of unsound, unsafe lending practices with respect to how they lent on this type of collateral, which was designed to be a 3-year repayment obligation that would be automatically refinanced. So it's quite interesting when bank counsel stands up and says, we were the golden goose. In fact, the client that he represents now took over an entity that was under criminal investigation, subject to a takeover order. So interesting argument to make. Secondarily, you now heard further facts in the record that my clients are somehow rich and that somehow they should have paid from other sources. Again, barren record because none of this ever existed in the record. And in fact, if we're actually going to talk about the record, we should then look at Sophia Popovich's affidavit, where she lays out that their entire business was the taxi business. Her late husband was a lease operator, and all they did was taxi.
But your argument also was that it was industry custom to extend loan payments past the balloon dates, past maturity, and that this didn't happen here, even though it had happened in the past. So how does that factor into your argument that we should look at the lender as essentially corrupt?
Well, again, what I'm saying was an industry custom, first off, which was an industry custom of a bank that got taken over by the federal government because of unsound lending practices. The bank that's sitting here is not the bank that was the lender, right? The corrupt lender was taken out of business because of their illegal, unlawful actions with respect to this industry. So that's how I would answer that question.
Did you tie in any illegal, unlawful practice with relations to your loan?
Sure, predatory lending. Right, whereas, because if they're going to argue...
That was argued below, that this was a predatory
yeah, of course, it was in the Sophia Popovich affidavit, yes. And remember, we don't have a full record. That's the problem, and that's why I'm here on argument. If we were going to ask these questions, which again, you guys are free to ask whatever you want of me, it would have been good to have a full record on these points, not left me as counsel, who happens to know a lot about the taxi industry, having to make points about people's amount of money they had or how they were going to pay for a loan or what the unsound, unsavory lending practice.
When discovery was produced, did you make any further demands for discovery? Because there was certain thousands of pages of documents that were turned over,
yeah.
I mean, I didn't count them. I'm sure you're in a better position to say exactly what the number is. But my question really is, did you make any further requests after that?
Of course, and then summary judgment was filed, and therefore that closes out discovery, right? So that's the problem. What they produced was the loan documents, right? When we talk about all this voluminous files and records, no email communications, no depositions were taken, none of the above, because they prematurely moved for summary judgment. And with respect to the commercial division part rules, which a lot of judges in this court know, that then shuts you down, primarily shuts you down. And that's the problem. I'm not asking this court to go so far as to make the ultimate decision on these legal issues today. What you should do, respectfully, is allow factual-based defenses on a full record. That is what we're here for today, because this is not the restaurant case. This is not the case where they could do other type of business. This is not the type of case where we have a record to even know what the executive order allowed or didn't allow. I did address this at length with Justice Barak. The record is preserved on appeal, and respectfully, this should be remanded so that we can develop a full record so the appellate court in the First Department can give some guidance to a taxi cab industry that has been decimated as a result of things before, but the death knell was COVID, impossibility, frustration, period. Thank you, Your Honors.
Thank you. Thank you both. Sklar versus 650 Park Avenue.
May it please the court, Tom Sotilli of the firm Lebelski and Associates on behalf of the appellants, the estate of Immerman, Mark Sklar, Paul Sklar, and Daniel Sklar. We appear before the court today to firmly advocate for the imposition of spoliation sanctions against all respondents. The fact pattern here, while demonstrating a quintessential spoliation case, bears
So the respondents don't deny that they removed the items from the storage room, right?
correct.
So why is there any spoliation?
Well, that's essentially a cumulativeness argument that they've raised that this court in the VOOM HD case has held is insufficient to rebut, or it's an insufficient ground.
There's no issue of fact there, right? The stuff is gone. They're saying we removed it. What's the issue?
The issue is that the spoliated video is at
It's
the
going to show what? That they removed it.
it's going to show the destruction of the property that is at the heart of the case. Cumulativeness is not a defense to relevance. This court has specifically rejected that argument in the VOOM HD case. Now, if we run through the fact pattern here, no litigation was held and the requested video was destroyed. Respondent Douglas Danzig, board president of 650 Park Avenue, is a practicing attorney. He's an esteemed practicing attorney with over 45 years of experience. He failed to issue any litigation hold whatsoever, despite the appellant Mark Sklar specifically requesting the preservation of this evidence. This is unique. This does
Right,
not
but
usually.
I think the point is that when you're making that argument, you want this video to support your claim that they destroyed the evidence.
They destroyed the
The property, rather.
in the storage.
Thank you.
Correct.
But no one's disputing that.
The video need only be relevant. It's okay if it's cumulative, in other words. This court in 2012 explicitly rejected cumulativeness as a ground to rebut the presumption of relevance. Although we do have other evidence pertaining to the destruction of our possessions here, the video in question depicts the precipitating events at a critical point at time leading up to litigation.
Is there a question as to what was stored there? I know there's an allegation that there was irreplaceable and original art. There were family heirlooms. Is that the import of the need for the surveillance video?
Somewhat, Your Honor. We have kept meticulous records of most of the contents of the storage unit, but of course, we don't know if there were additional things in there beyond the records, what our records have shown. And the point is, we are deprived of determining that because the video was spoliated now, and essentially not entering spoliation sanctions here.
Wouldn't the plaintiffs be in the best position to say what was inside that storage unit, right? They would have to establish that.
They would, but the Supreme Court essentially rewarded the spoliating party by failing to issue spoliation sanctions because, you can't, if you're spoliate evidence, you can't use that spoliation as a sword to say we don't know what was in the storage unit.
Counsel, it's interesting. Was that your argument? Was your argument that we needed the video to kind of clarify or help with determining exactly what property was in the storage unit?
No, the argument was that it's relevant. The video need only be relevant. Again, in the VOOM HD case, the cumulativeness argument was rejected by this court. The standard is relevance.
But I think the problem is that the thought was it may be relevant, but is it really necessary given the fact that there was no dispute that the items were removed from the storage bin? So now you're saying, well, we needed it because we wanted to see exactly, we wanted to be able to show exactly what was there and help us in terms of categorizing it, et cetera. That's a little different, I think.
Well, the evidence, the video would have shown that, first it would have corroborated our deposition testimony and our
But
version
again,
of
no
the
one
events.
disputes it. Everybody agrees that they cleaned out the locker.
Well, we don't know the manner in which the evidence was destroyed. The factual backdrop here is that there was a grudge by the building superintendent, William Newhook,
Counsel,
against Mark Sklar.
I'm sorry. The manner in which it was destroyed, how would that possibly make a difference if people put all the property into garbage bags and put it on the street? If someone, before putting it into the garbage bags, took an axe and chopped everything up? I'm not saying that it, God forbid, but if the essential fact is unchallenged, why does the manner of destruction or disposal make a difference?
Because the manner of destruction or disposal would certainly be persuasive to a jury, and we have been deprived of the ability to know
Persuasive
whether,
to a jury as to what?
as to the intentional torts that we've brought, as to whether there was actually a grudge, whether gleefully Mr. Newhook disposed of the contents.
You have unlawful eviction, negligent trespass to chattels, negligent hiring, and negligent supervision.
And conversion.
And conversion. And so the manner in which the goods were removed from the storage bin would go to any of these?
Yes, and it would be persuasive as to the elements of those claims. And I respect that your honors are concerned with the cumulativeness, the cumulative.
It's not about cumulativeness. It's about relevancy. How is it longer relevant when they're admitting that they took it out and got rid of it?
It's relevant because we have the tort of conversion where we're alleging that the items were converted.
But they're not.
To the extent you have a conversion claim, they're admitting they took it.
Are you saying they sold it?
No, the taking of the items, which is the heart of the conversion claim, is relevant to the conversion claim. I apologize if that seems circular, but that's the conversion. The conversion was depicted on the tape, and it's therefore relevant.
But they've admitted to removing the documents.
The goods.
The goods, rather.
Right.
They've admitted to it. You've basically gotten what you wanted in that regard. They've already admitted that. How?
And yeah, we'll think about it a little bit more. You can think about it a little bit more because you have time on rebuttal.
Okay.
Thank you.
May it please the court, Seabriggs Johnson for the defendant's respondents. I think you all hit the nail on the head on the spoliation. We're not contesting that we took the items out. As far as I'm concerned, the way we took them out does not add anything to his conversion claim.
Well,
to his
yeah, the
trespass
only
claim.
thing is that you knew there was pending litigation, and so why destroy the video? Even though everybody agrees and you admit that you took the goods out,
Sure.
why, you shouldn't have destroyed the video.
Sure. Well, I think there's definitely ambiguity in the record regarding when the video was overwritten. So we have the closing on March 10th, 2016. We have the email from Mr. Mark Sklar on April 6th saying, we're going to bring a claim. Our super says that the video was overwritten 7 days after there's no incident. Yes.
In 7 days, you said?
7 days, yes.
The items were removed on.
It is unclear on the record the exact date that they were moved, but it was a couple of weeks after the closing.
Well, then maybe that's the reason why the video would be important, right? Because there's a dispute as to what day. Because if I believe I read in the record that it was emptied on April 4th. If you're saying there's an April 6th email, that's surely within the 7 days.
No, it's not clear on the record when it was emptied. We don't know that from the record. It is unclear.
I thought it was on or before April 4.
On or before, right. We don't know from this record when the video was deleted.
Okay, well, it's on or before that the locker, that the storage locker was, the contents were discarded, and then the closing was on March 20th.
March 10th. The email was sent by Mark Sklar on April 6th.
I have closing was held on March 20th.
It's March 10th. It's definitely March 10th.
March 10?
Yeah.
Okay, so we're talking about a little less than a month later that the locker is, the contents of the locker are disposed of?
Right, and I will also add procedurally, and I think you saw this in the brief, he moved for spoliation relief in December 2019. That for the same exact relief he's seeking now, he did not file a notice of appeal, and he did not move for renewal. And this is the same exact relief. And if you don't file a notice of appeal, and you don't meet the elements for renewal, you can't seek the same relief twice, right? You're procedurally barred. I want to go briefly to the abandoned property argument, which I think is the most important thing here. Mr. Sklar signed a contract of sale on December 10, 2016, where the contract of sale said explicitly that the storage unit is transferred immediately upon the closing, and that the property left in the storage unit is deemed abandoned as a matter of law.
But he claims that he had a conversation with the new owner.
Yes, he did.
And the new owner stated that he or she was not in any hurry to use the storage locker, that
Right.
Mrs. Sklar could keep the items in the storage locker.
Right, but the problem with that is that it violates the parole evidence rule, right? Because when you have an agreement that's clear, unambiguous, that leaves no stone unturned, any evidence of an oral agreement, especially in this case when we have a merger clause that says any agreements to modify need to be in writing and by the party to be charged, that doesn't come in. So any oral agreement is meaningless if you have a clear and ambiguous contract. And so he knew for 2 years, right? His mother had passed away 2 years before the closing. He has said that he knew that he needed to deliver the unit, the storage unit in the apartment, broom clean, free of items, that the new owner took it as is on the date of the closing, and he did nothing for 2 years. He did nothing on the closing, and he did nothing for a couple of weeks after.
Counsel, was there any obligation that the plaintiff be notified of the emptying of the locker, given the fact that he lived in the same building?
There was nothing in the contract that said that. I understand that plaintiff lived in the building and he had been there from 1994, so perhaps a courtesy call, that's what I would want. But, we live in a world where you sign a contract and it says you take it as is on the date of the closing, and you knew about it, and you testify and you later on that I knew that I needed to deliver the apartment and the storage unit broom clean, and I knew I could have rented a storage unit, and I knew I needed to get that stuff out, and there's a presumption as a matter of law that when a tenant quits a premises, that the property is deemed abandoned unless they prove otherwise. I think that's it. So unless there's any other questions from the court, I'll rest on my brief. Thank you.
If I may, to the abandonment issue, Your Honors, the property was not abandoned because it was locked, and I'm pretty sure we cited case law that even after legal possession has ended, a landlord cannot resort to self-help and just break locks and dispose of possessions. That's not the law in New York. It's not so.
Counsel, this is not a landlord-tenant situation, right?
It's
So let's be a little careful there.
It's a proprietary lease, so it's while it resembles an ordinary deed to a property, it is technically a proprietary lease. The items.
I guess the question that I would have is that we know that where it's a landlord-tenant situation and property is left behind, there are certain protections that inure to the tenant, so that everything in the apartment that remains after the tenant has been evicted is protected for a certain amount of time. It's put into storage and so on and so forth. But in a co-op situation, have you argued anywhere that exists, that those protections apply?
We have argued that where the legal possession has ended and actual possession continues, the landlord cannot resort to self-help. And it is a lease, it is a landlord-tenant situation. As
Landlord, so I beg to differ with you. It's a proprietary lease. There's a sale of shares, and there's a new shareholder, and you have a situation where an as-is contract has been executed. That's a big difference from a rent-stabilized apartment that's emptied, isn't it?
I submit that it is not, and again, self-help is not an available remedy, especially in this case where Mark Sklar lived in the building, was actually in the building when the items were destroyed. And if I could just address the timing with respect to April 4th, the items were removed on or about April 4th. That's what the record shows. This building superintendent Newhook testified that the video was maintained for a period of 7 days and overwritten on a rolling basis. So in other words, it wasn't that it was overwritten in blocks, it was that it was, the April 4th video would have been overwritten 7 days after that. So there was ample time, if Mark Sklar's request for preservation was made on April 6th, to suspend automatic deletion procedures, which was not done, to preserve the video. And again, there's a broader policy concern here. If sanctions are not issued, in this case, where an esteemed litigator and board president did not issue a litigation hold, future litigants are on notice that they can essentially take a gamble and they can say, I have this evidence that I know is potentially damning to me, and I'm the only one that knows it exists. I cannot disclose it, and at best, I'll get some minor sanction, or at worst, rather, I'll get some minor sanction, and at best, I'll get no sanction. And that just cannot be the law, and that is not the law under the Zubilaki test, under the VOOM HD test, which incorporated the Zubilaki test, and under the Pegasus test. The only standard is whether there was a duty to preserve, which there was, upon the reasonable anticipation of litigation, and upon Mark Sklar specifically requesting the preservation of that evidence, whether the evidence was destroyed with a culpable state of mind, which it was because a failure to issue a litigation hold constitutes gross negligence, which goes to culpability, which the case law supports, and the evidence is relevant, even though it may be cumulative. It depicts the destruction of the property that forms the heart of all of the claims here. So we've met the Zubilaki test, and I understand that the court is concerned with the cumulative nature of the evidence, but cumulativeness is not a defense to relevance. Relevance is what the court is concerned with, what the court, this court has been concerned with.
Thank you, thank you both. Thank you. Have a good day. You too, thank you. Wallach versus United Synagogue.
May it please the court. Jonathan Bernstein from Goldberg Segala for the defendants, United Synagogue of Conservative Judaism and United Synagogue Youth. We submit before the court asking for a reversal of the lower court's denial of our motion to dismiss on the pleadings on the grounds that the CVA does not, Child Victims Act does not apply to the facts of this case. Facts are very, as they are alleged, it's very simple that this was a 16-year-old boy who claims he was sexually assaulted by a counselor in a youth program.
You're saying that the Child Victims Act doesn't apply to this case at all?
Does not apply to this case because it occurred outside the state of New York.
So what about CPLR 202, the borrowing statute?
I don't believe that CPR 202 plays a role in this because this is a revival statute. That deals with if there's a plaintiff who is a non-resident of whether the 202 applies in that situation. But in this,
202 says that it applies to persons residing in New York.
Well, I don't think that 202 applies because of the fact that because it's a revival statute, you can't look at 202, you have to look at whether the intention of the...
So then your position would be, had this action been brought within time, then maybe it would apply, but because of the timeliness of it, then it doesn't. Is that basically?
Correct, that certain claims were revived by the Child Victims Act and certain claims were not. So the SH case that was decided by the second department dealt with the situation where the plaintiff was from Florida and tried to sue in New York because the diocese was a broken diocese, and the court said, no, it doesn't apply.
But that plaintiff was in Florida. We have a New York plaintiff and a New York defendant here, right? That is different.
Well, I think SH is the case that the lower court relied upon. And what came out of that, I think, are three elements. Where was the individual who allegedly abused the child from? In this case, it was Florida. Where did the incident?
We're not in Florida, we're in New York.
What
we have New Yorkers, New York residents, and 202 favors New York residents where the statute of limitations for an out-of-state based claim is shorter. So why are we talking about Florida?
The reason I'm talking about Florida was because the individual, Mr. Cohen, was from Florida. The acts occurred in Florida. So CPR 214, the Child Victims Act, indicates acts which would violate the New York penal law, which would act in the... I'm confused, so I'm going to try to clarify this. So are you telling us that had this victim, alleged victim, timely brought an action within the, where was it, Wyoming statute and the New York statute, that he could have brought the action here in New York? What I'm saying is, the first inquiry is... I need a response to that. What I'm trying to get is, you have to look first at, does the Child Victims Act apply to this case? That's not the question that I'm asking you. I'm asking you, had he brought the cause of action timely, could he have brought it up in New York?
Right? Under the CPR 202, yes, if you brought it back in the time
So
period.
you're saying that the revival statute then doesn't revive that because it happened outside of New York, that the revival statute only applies to sexual assaults that were committed in New York.
Correct. And the reason,
what is that based on?
because the statute says, CPR 214G, conduct which would constitute either a...
Which would constitute a violation of the penal law in New York.
Right.
It doesn't say which violates the statute in New York.
Well, if you have to read the statute narrowly, which would mean that it would have to violate New York.
No, but the converse of that is that if they intended to mean that it violated New York statute, including its territorial restrictions, they would have said that. But because the intention of the legislature was to make this, we believe, to open up a window that was foreclosed, I just don't see any reason why we would foreclose stuff that at the time, if they brought it timely, they could have brought the action in New York. But now under the revival statute, we're excluding those because they happen outside of New York.
And I'm saying because of the reference to the various penal code sections that are relied on in the CPLR, if you read, you would be reading those out of the statute, which would violate. There would be no reason to have those penal law statutes in there, and there can be no penal law statute.
Counsel, that there is a distinction between the term violated and the term would have violated, right?
Which would constitute. Is what this says.
Would constitute.
Which would constitute.
In order-
So you're saying it's strict statutory interpretation as to whether or not the revival statute is applicable or not.
Correct. And
Okay.
if the,
And you read which would violate to mean that,
Which would constitute.
which would constitute to mean that these actions would not fall under the statute.
correct, because in order for the penal law to kick in, the actions had to occur in New York under CPL 20.10 and penal law 10. Now, for reference,
But why isn't that just a description of what would constitute a sexual assault? Like, it's not specific, it doesn't say penal law 130 point such and such, penal law 130, right? It just says the acts that would constitute, meaning the sexual assault acts, because that is a broad statute, it covers various different types of sexual assaults, right? But which would constitute is just giving it some definition. It's not really limiting it to that it had to happen here in New York. It doesn't say that, and in fact, in the legislative history, it doesn't say that anywhere.
well, the legislative history, there's a section that actually my opposing counsel actually cited to, that's on page, 10 of their brief, which was the State Assembly memo. The CVA would open the doors of justice to the thousands of survivors of children abuse in New York State. Abuse in New York State. But what I'm saying is, because it's a revival statute, it has to be interpreted narrowly, and the only reason those penal law sections are in there.
You're interpreting would constitute a sexual offense as defined by Article 130 to be the equivalent of would violate the Article 130.
Right. So, for example, in this situation, there can be no such violation because it would violate the penal statute of wherever they were in Yellowstone National Park.
You know, counsel, I'm looking at the justification section of the Assembly memo, the sponsor memo, and it is so expansive. You're asking us to look at this narrowly, right?
Yes.
Look at it through the lens of strict construction.
Yes.
But here it says, besides the fact, it begins, the societal plague of sexual abuse against minors is now well documented, and it goes on to say in the second paragraph, compounding the effects of these crimes against children has been the consistent locking of the courthouse door to child sex abuse victims who wish to have their day in court against their abusers, typically as a result of the passage of time in bringing these claims. And you're asking us to disregard this, as my colleagues have pointed out, that there's no specific penal laws that are cited or named within the contours of the statute. You're asking us to just look at this with the most narrow lens possible and say, you're out of the ballpark. I don't get it.
I think because it is a revival statute, unlike this case, I have cases in my office that are dating from 1960, 1950, 1945, so it has to be strictly construed. And the analysis that was done by the SH court did talk about when you can apply something extraterritorially. And this isn't it, because it's not in the statute. I see I'm out of time.
May it please the court, Matthew Schock from Levy-Konigsberg on behalf of the respondent.
So, counsel, obviously the question to you is whether you agree with your adversary's interpretation of the statute.
I do not, Your Honor, and I think the lower court correctly interpreted the statute, as did the Second Department in the SH case. The lower court specifically cited to the SH case in the Second Department, and I'm going to just read literally from page 7 of the record, where the lower court cited SH for the proposition that a close reading of the actual language of the statute, as the CVA case here, evinces that it is not a violation of one of the enumerated penal statutes that is required to trigger the revival of certain civil causes of action, but rather it is conduct which would constitute a violation of the penal law. And as this court has specifically indicated before, that is very different than a requirement that a violation must be, that there must be a violation. As Your Honor mentioned, saying that conduct which would constitute a violation is specifically just referring to the acts and conduct within the statute. Here, we have a plaintiff that was a New York resident, a defendant that was a New York corporation soliciting business and its program to its New York residents, and the legislative history clearly has an intent to benefit New York residents and New York victims of child sex abuse.
And the causes of action here, they arose in New York State, right? The triggering sex assault was outside of the state, but what your claims are occurred all in New York State.
That is correct. Just briefly on the facts of this case, when the plaintiff signs up for a camp in his home state of New York, and just because he boards a bus that part of the activities crosses state lines, that does not take away from the fact that we have a New York resident here and that the defendants are from New York as well, and that, as Your Honor suggested, the causes of action still arose in New York.
But the actual sex assault occurred outside of New York.
That is correct. And if I could just...
This is completely different from SH, right, where everything occurred in Florida.
That is correct. In SH, we have a Florida resident, we have a Florida abuser, and we have a Florida sexual abuse, which is a very distinguishing case from here. And if I could just point to the Shapiro versus Syracuse University case cited in our briefs, page 11, the Fourth Department specifically held that the CVA applied to two plaintiffs, even though they were sexually abused in the state of Massachusetts, for the sole fact that the plaintiffs were New York residents.
But Shapiro dealt with the borrowing statute, right? It didn't really talk about the, I guess it's extraterritorial application of the Crime Victims Act, right?
That is correct, Your Honor. The court in the Fourth Department did go on to state that the claim, which is another underlying fact here, that a claim that accrues in favor of a New York resident will be governed by the New York statute of limitations, regardless of where the claim accrued. So it is our contention that despite the fact that technically the abuse occurred outside of the state, the overwhelming fact here is that the plaintiff was a New York resident and should be afforded the benefit of his home state's protections and statute of limitations. And if the court has nothing further, we thank you for the time.
Thank you.
Just one final point. Regarding the Shapiro case, as Your Honor was correct, it didn't deal with what we're talking about here, but there was two parts to that case. The other part dealt with Syracuse University, where there was an allegation of abuse there. And the court did indicate that for pleadings purposes, that there had to be a pleading of lack of consent under Penal Law 130.35, which is kind of what we're saying here, that for pleadings purposes and to get the statute of limitations to apply, the revival statute to apply, you have to actually trigger the penal law. And that didn't occur here because it happened outside the state. And with that, I'll submit. Thank you for your time.
Thank you. Thank you both. People v. Pedro Carnegie.
Good afternoon, and may it please the court. Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing Mr. Pedro Carnegie. Recognizing the severity of the underlying offense in this case, for an offender who has consistently and actively sought out mental health and drug treatment of his own accord since he turned himself in to the police for this crime, the maximum term of 10 years of post-release supervision is excessive. And there are several relevant factors here that show why a more tailored term of supervision is appropriate in this case, beginning with Mr. Carnegie's emphatic expression of remorse. After the complainant came forward in this case, he turned himself into officers in the Bronx with no...
After denying the allegation, right?
That's correct, Your Honor. It took 2 days for him to admit to what he had done, but at that point, he turned himself into...
What happened here, this was against a 13, 14-year-old, and it went on for 23 months. It was, I think, 8 or 9 days shy of 2 years.
Your Honor, just a point of clarity, Mr. Carnegie pled to 2 incidents that were 6 days apart.
I'm saying the allegation.
Your Honor, nobody is contesting the severity of the underlying offense. And my point in mentioning Mr. Carnegie's emphatic expression of remorse is that it goes to the question of what the appropriate term of supervision is with respect to his risk of reoffense, because that's the issue that's animating how much supervision he should receive. And for someone who, it's true, it took 2 days for him to admit to it, but did turn himself in when there was no suggestion that there would be any criminal action taken against him. In fact, I'm quoting from what he said to the police, "No cops were called, I should be punished." You know, this is someone who...
Well, we should be clear. This was his stepdaughter, right? And after the allegations were made, he was ousted from the family, right? He was ousted from the home.
Your Honor, there was no suggestion that they were going to call the police or that any law enforcement would be involved in this.
Well, I don't know that that was ever in the record, but I don't know that we can make, in other words, I don't know that we can make that determination.
Well, regardless, Your Honor, the point stands that he turned himself in, and he attempted suicide twice after this. You know, again, this goes to the emphatic expression of remorse that he showed and what that means for his risk of reoffense. He began seeing a psychiatrist of his own accord without anyone else, you know, requiring...
So he's already served the 3.5 years incarceration. You're looking for a reduction of the 10 years post-release supervision. And how much post-release supervision do you believe that he should be sentenced to?
Well, Your Honor, we're asking for the 3-year minimum, but certainly some term less than the 10 years. You know, it's relevant to consider the fact that the legislature determined that there is some category of persons who have committed this exact offense for whom 3 years of supervision is enough.
How much time was the defendant facing? Was he facing consecutive terms? What was the mandatory aggregate?
Your Honor, the maximum possible post-release supervision in this case was 10 years, so he did get the maximum. And again, you know, the legislature determined in setting the sentencing range here that there is some category of persons for whom a lesser term is appropriate, and he fits that bill for a number of reasons.
Did he have a maximum aggregate of 16 years?
Excuse me, Your Honor?
Did he have a maximum mandatory aggregate of 16 years?
Your Honor, I believe the maximum custodial sentence was some term between 2 and 7 years.
On each, so it would have been 14.
14, yeah.
In terms of a term of incarceration.
Yes, Your Honor. But again, he served above the statutory minimum for what he was given. And there are a lot of distinct systems in play here with respect to the supervision that counsel in favor of a more tailored term. You know, it's not just that he has post-release supervision, for which there are a host of technical requirements that he has to comply with. He will be monitored pursuant to SORA until he dies. For the rest of his life, he will be reporting annually where he lives, reporting any moves he makes within 10 days, reporting to a local agency every 3 years.
Well, SORA has nothing to do with post-release supervision. And SORA is purely registration. SORA does not have any type of supervisory component to it. It's simply registration so that we know where individuals who are sex offenders are residing. There's no, as I just said, there's no supervisory component to SORA.
That's correct, Your Honor, but may I finish responding, Your Honor?
Sure.
That's correct, Your Honor, but the point is we're not asking for Mr. Carnegie to be, you know, set loose, so to speak. The point is there will still be systems in place here, and for an individual such as Mr. Carnegie, who since this conviction has been doing everything right, getting treatment, seeking it out of his own accord, seeking out mental health.
When was the conviction?
Excuse me?
The conviction was 2019.
That's correct, Your Honor.
May 2019, May 9, 2019, so we just hit 4 years. Is that really enough time to make a determination as to how well he is or is not doing?
Well, Your Honor, he's been on
When he was incarcerated for, I guess, 3.5 of those years.
Well,
I don't know how much time served he got.
He was incarcerated for 3.5. Your Honor, this is stepping outside the record for a second, but during that time, he participated in anger management programming. You know, he participated in.
But my point was, was he in the community or was he incarcerated?
He has been in the community for almost a year.
For almost a year.
And-
So is that enough time to make a determination as to how well he is or is not doing, or what his prognosis is?
Based on how he's done, I would say yes, Your Honor. He has asked his parole officer to put him in drug treatment. That was not something his parole officer offered. It's something he requested. He's been in drug treatment in Rhinebeck, New York for that time. He works as a cook in that facility, is getting his GED, and most notably, he was adjudicated a level 1 risk under SORA. So the SORA hearing court determined this was someone with an incredibly low
And
risk.
as I said before, SORA and post-release have nothing to do with each other.
That's-
You have time on rebuttal. Thank you. So I'm never quite sure on these cases, does the less is more have anything to do with post-release supervision? Is it applicable? Do we know?
Thank you. May it please the court. Charles Hickerson for the people. To answer Your Honor's question, whether less is more has anything to do with post-release supervision, Your Honor, yes, we would argue that it does, as the defendant can earn time off of his post-release supervision through 30 days without parole violations, Your Honor.
Right. So according to your adversary, he's been out for about a year now. And so as he progresses, that 10-year post-release supervision term would be decreased, assuming he does well.
Yes, Your Honor, that's correct. And if I may just address a few things presented earlier. In terms of his behavior or indicators of reoffense, he is in his other felony conviction, he was twice cited as a parole violator. And to the issue of remorse, I do just have to reiterate that, as Your Honors pointed out, this remorse did never surface over the 2 years of the abuse towards his stepdaughter. I also would like to clarify something about his maximum exposure that seemed somewhat unclear, Your Honors. He was facing, on the top count alone, 7 years of incarceration, 10 years post-release supervision. His maximum exposure on everything on the indictment would have been 16 years, because there were 4 different occurrences listed on the indictment. And so we had 7 plus 7, 14 for the top counts, and then 2 on each of the forcible touching, a year for each of those. Just wanted to clarify. And in terms of SORA versus post-release supervision, Your Honor, I would just say that I agree and that they serve different purposes, and I think that defendant could stand to benefit from post-release supervision. If the court has no further questions, the people will rest on our brief. Thank you, Your Honors.
Thank you.
First, Your Honors, I would like to note that the prior conviction to which my adversary referred there's an 18-year gap between that conviction and the one that's being reviewed right now. So
isn't all this foreclosed by the waiver of right to appeal?
Not in our view, Your Honor. The oral colloquy here invalidated the waiver for a number of reasons, but the most important one is that the lower court said to Mr. Carnegary, and I'm quoting from the plea transcript, "This means that these proceedings become final. They will not be reviewed by a higher court, the Appellate Division of the Supreme Court First Department, and or the Court of Appeals in Albany." The Court of Appeals has held over and over again that presentation.
Wasn't that, to the extent that that was a misstatement, wasn't that clarified by the written waiver which the court elicited from the defendant that he read and understood and had counsel?
Your Honor, this court has held that a written waiver is no substitute for an on-the-record explanation of the right to appeal, and it's waiver.
Substitute, because there wasn't a failure to explain. At worst, it's a misstatement that was corrected by the written waiver.
Well, Your Honor, that misstatement was enough that even the inconsistent statement following it by the court that there were other rights that would not be waived doesn't cure it within the colloquy itself. Those inconsistent statements only maximize confusion, which this court has also held in People v. Francisco, which is a 2019 case. But if I may just finish the
Yes, please.
Thank you. As to the written waiver, it's not a substitute, but even if it could be, it contains its own critical flaw. It introduces new ambiguities. It suggests that the right to appointed counsel for purposes of the appeal would have also been waived because it reads, I understand that the right to appeal would have allowed me, with the assistance of an attorney, to raise all these issues. I'm waiving that right to appeal, also in contravention of Court of Appeals precedent. So for those reasons, the waiver is invalid. And just briefly, I know I'm out of time, returning to the merits here. You know, this is someone who is invested in
Oh,
his
I'm
own-
sorry, you are out of time now. Okay. Thank you.
Thank you.
Marta versus Isa.
May it please the court, Bruce Povman for the appellant from Pena and Khan. Your Honors, I submit to the court that pretty much every issue raised in the motion for summary judgment and in the underlying complaint concerns issues of fact in this case. The lower court chose to harp on one particular issue, which is kind of a subset of one element that was raised in the complaint, and ultimately found an issue of fact on the issue of the bed alarm, but at the same time then dismissed all of the rest of the complaint, even issues that were never raised by the movement in his papers. So the court went, well beyond what the movement even offered in its proof, in limiting us to the issue of whether that specific bed alarm was appropriate for this particular patient.
So in reviewing the record and the papers, it appears that there may be quite a few issues of fact that would have to be raised, not resolved by a fact finder. Is there anything anywhere that explains how the patient, the decedent, got out of that bed?
No, not at all. And we would submit we would be enabled to argue to the jury based on our expert's testimony as evinced in his medical affirmation that the bed rails may not have been raised at all on this occasion, because this patient was a functional quadriplegic, which means the patient essentially could not move on her own. She could not even roll over to avoid bed sores in bed. The notion that she was able to sit up, somehow climb over these bed rails, land on the ground, hit her head because she was bleeding from the back of the head from a subdural hematoma, and then sit up and be in an upright position, all within 5 seconds or less, mind you, because this nurse Butler that the lower court chose to believe, even though there are many reasons to seriously question her testimony, self-serving testimony, we intend to argue to a jury that...
Before we get to your expert.
Yes.
Right? The hospital's experts' affidavits sufficient to sustain their burden?
Well, I would argue not, Your Honor. First, the nurse gave medical opinions and offered...
Isn't that a Scribner's error, that portion?
I think even if the court was to accept to one nursing affirmation or affidavit and one medical affirmation of the movement, even if the court accepts it, and I would argue there are plenty of reasons not to, conclusory being a big one, credentials being a second one, a nurse giving medical opinions a third one, but I would argue our medical affirmation it would raise issues of fact on every point that they bring up anyhow. So even if the court was to accept it, it wouldn't be...
Did your medical expert address the issue of the infection being contributory as their Dr. Segal did?
Well, now the movement has conceded in its appeal, conceded that causation from the accident and the death is a question of fact for the jury. That and it's in their papers, I could cite to you the page, it's right in their brief, that they concede that, because they claim the lower court got two things right, and those two things, and one is that the bed alarm is at issue, and two, there's an issue of fact as to causation and death. And they're very happy with those two because that basically gets rid of 90% of the rest of our case. But they can't now walk away from the two that they agree are issues of fact. What I'm arguing to the court is that the other 90% are issues of fact as well to those two items that the movement, that the respondent agrees are issues of fact, not least of which is what Your Honor mentioned of how did she get out of this bed in her condition? How long was she on the ground for? Why was she permitted to fall out of her bed if she was known to be a high-risk patient? And how did the nurse supposedly get there in under 5 seconds when and she was supposedly only 8 feet away when it all happened? Our doctor says that's impossible. It's physically impossible. And I would argue you don't even need necessarily a medical doctor to say that. We have one. We have one to say it, but I would argue you may not even need one to say that under the circumstances of this case.
Thank you. You have time on rebuttal.
Good afternoon, Your Honors. I'm Judy Shamatsu from Wilson-Elster for the hospital. To answer the question of where in the record it is how she fell out, so the nurse testified that it appeared to them when they entered that she slipped through, there's 2 rails that go on the side of the bed. On each side there are 2. And it appeared to the nurse that she slipped through where there is an 8-inch gap between the 2 rails. And that
something that the hospital should have been concerned of, considering that you have this 8 to 10-inch gap and a patient that weighs 62 pounds.
That is a triable question of fact, Your Honor. We did not appeal on that issue. That issue is going to be tried. That is the issue that needs to be tried, whether...
Now, in terms of the affidavits of your experts, they both say within the standard of care, they both relate to that phrase, but none of them describe what that standard of care is.
Sort of. I think the truth is that our expert didn't use the magic words of the standard of care requires, but she did go through, and I just want to get the page numbers right here, page 26 of the record, paragraphs 21 and 22. At the front of the affidavit, as they always do, this is what happened, right? And she identifies the fall precautions that were in place, the socks, the rails, the alarm. And then at 21 and 22, she does 2 things. 21, she says, these were the things that they did. Again, the socks, the alarm, the rails, and this is appropriate. And I think 22 is where it's really at for the defense expert's affidavit, because she says, under these circumstances, the standard of care does not require, and she lists the additional things that weren't done, which are the alternatives, right? If you're going to do more, these are the things that you would be thinking of to do. And she says within her expertise are the things that were not required here by the standard of care. And that is why I submit to Your Honors that the affidavit is not conclusory, because it answers the question, what should have been done and where is that line in that expert's view. That
does it answer the question as to what should have been done, or does it answer the question as to what was extra that could have been done but wasn't necessary?
It answers all of those questions, Your Honor, by listing the various interventions and then saying these first set that were done, this is what is required, and the second set is not required because, and it lists all of those things. That part of the case, there is no question of fact raised on, and she is the appropriate person to opine upon that because it is based on the nursing assessment that the fall prevention is done. So she's the right person to talk about that. She does talk about that. On that issue, there is no question of fact. Yes, I think the case will have to be tried on whether that bed with that alarm was added. I think it is going to have to be tried on that issue. We didn't appeal from it. We get it. There's a question of fact on whether this was the right bed for this patient, seeing as how she was so little by then that she fell through the 2 rails. So yes, I do think that is going to have to be tried. I think the one thing that definitely should not be tried is the negligent hiring and retention, which I think my colleague and I agree, based on his reply brief, that seeing as how it's duplicative of the vicarious liability point, both of them need not and should not go forward, and I believe that was conceded on reply. So that's where we are, and then there's the gray zone in between. And I do maintain, Your Honors, that while the issues relating to the bed and the alarm are triable questions of fact, the rest of them, including whether the nurse responded in time, because again, if the alarm, so what the plaintiff is saying is that the alarm was going off and you didn't respond to it. So the nurse testifies, I'm sitting at the nursing station. I have been sitting there for a while. And she testifies very specifically that she hears the alarm come on, not that she realizes at some point that there's an alarm that's already going on. So what the plaintiff is saying, that couldn't have happened. And what I'm saying is that that is not up to a physician. There are all kinds of experts, more accident reconstruction type scenarios where you could assess. But by the way, on the way here, I stopped at the light. At the 5 mark for crossing the street, people cross Madison. 5 seconds is enough to get into a room that's 8 feet away from you. So that is my point, is that the plaintiff's medical expert is not qualified to rebut or challenge a nurse's testimony who says, I sat there, the alarm went off, I got up, I went to the room, it took me 5 seconds. That the medical expert cannot challenge.
Thank you.
Thank you, Your Honors.
5 seconds is enough time to get to the room, but she was not the first person to the room. A night float intern was the first person in the room. And 5 seconds is not enough time for a functional quadriplegic to sit up, climb over or through the rails, fall down, and then sit up again. That's a 5-second time period. Not how long it may have taken her to get there if she did do that, but how long it would have taken this patient to, because if the alarm just started, it's a movement alarm. As soon as she sits up or touches the side rail, it's supposed to go off. So the 5 seconds that count is 5 seconds for this quadriplegic to do what she did, which is not possible. But contrary to what defense counsel is saying, the lower court did not give us those issues that she's giving us. The lower court gave us the issue is whether the bed alarm was a departure and approximate cause of decedent's injury and death. The balance of the motion seeking dismissal of the other claims is granted. So we're not getting whether the side rails were 10 inches, was that a safety issue? We're not getting that to go to a jury. We're not getting the issue of whether they were checking up on her every 30 minutes. We're not getting the issue whether they should have had floor mats, which is in our bill of particulars, underneath her, so if she fell out, she would have landed on a floor mat, not on the ground. The lower court, I would just call your attention, gives us one issue only, the bed alarm. But right now defense counsel is agreeing there are other issues, including the nature of the bed, the nature of the side rails, that the lower court did not give us in this decision. So I would like to just point that out.
Thank you. Thank you. 821. Thank you.
What did it say, 21? I missed that.
It's just about who was in the room first.
Oh, okay, got it.